अरे सब आ गया in time, intact. Oh, good. This will go live in YouTube.
लाइव चालू कर दिया सर?
चालू कर दिया ना?
हाँ,
तो मुझे एक लिंक भेज देना।
वही लिंक वही है, भेज देता हूँ।
कब भेजा?
नहीं, वही पुराना लिंक है जो पहले भेजा था
यार अभी से तुमने लाइव कर दिया तो ये तो हम जो बोल रहे हैं सब वो हम आ जाएगा।
तो बंद कर देता हूँ।
बंद करके मीटिंग शुरू करने से पहले स्टार्ट कर लो।
ओके, ठीक है।
ठीक है। Anup ji, let us start now because time is heavily tied up.
So, Namaste, good afternoon, Kushamdeep, welcome all my friends. I'm Anup Prakash Awasthi, advocate on record at Supreme Court of India and your fellow insolvency professional and promoter, non-executive director of Persistent Insolvency Professional Private Limited. I have been given the honor to be the moderator of this panel discussion, which has two components. First component is the recent amendment to the insolvency resolution for corporate persons, third amendment, which has happened on 13th of September 2022 and which has regulated the fee of a resolution professional in a CIRP. The other component of this discussion is the judgment of Honorable Supreme Court of India in the matter of state tax officers versus Rainbow Papers Limited, Civil Appeal number 2568 of 2020, decided on 6th September by Honorable Justice Srimati Indira Banerjee and Honorable Justice A.S. Bopanna. And for the purpose of discussion, as panelists, we at Persistent Insolvency Professional have attempted to present the most distinguished and most celebrated, prolific genius from the field of insolvency and bankruptcy laws in India, persons who have not only been instrumental in shaping and settling the insolvency regime into motion, but also have been the pioneers and path breakers in settling its jurisprudence. So with these words, I invite Mr. K.Z. Vinod, our Managing Director, to formally introduce our panelists and our esteemed guest. Mr. Vinod, please.
Thank you, Anup-ji, and welcome all the participants, designated invitees from the bank. And this is the time I'm just giving an introduction. Even there is no requirement of introduction for all our IPs because we have started from the classes of all these senior people who are lined up for the panel discussion. But still, Ashish Makhija ji, no need of giving any introduction. A leading advocate, committees, a chartered accountant, and a well speaker in all matters, whatever coming up in the IBC code and all those things. GP Madanji, advocate, committee secretary, chairman NCLT, and this Chamber of Commerce, etc. The most prestigious guest with us is Sanjeev Pandaji. Sanjeev Pandaji now is a consultant DSK Legal, but the importance of Sanjay Pandaji in this forum discussion is because Sanjay Pandaji was deputed with IBBI since the inception of its laws and regulations and was a member in the drafting committee. Then after, Sir was posted back to SBI as the head of NCLT. Nipun Singh ji, no need of any intro because Sir is presented that many platform presentations for us. In fact, I am seeing the Ningji in OT program. In a single, within an hour, he got captured all the soul of all the people who presented there. Nipinji is a chartered accountant and a legal advocate in corporate law as well as in IBC. A great personality of involving the things matter with more attraction and more involved, more effectively and efficiently. This time I'm just giving a brief intro of PAPPL, means Persistence Insolvency Professionals Private Limited. It's a conglomerate of professionals, 127 regulated professionals from IBBI, and they are also chartered accountant, cost accountant, company secretaries, advocates, corporate trained people, as well as banking sector people. This is what the company, in general, I just wanted to get into. We are basically involved in the stress assets management, which is included ODS arrangement and compromise arrangement, merger, demerger, acquisition, and all these stuffs. Especially, we are also funding for OTS as well as for resolution applicant and even for the compromise arrangement also. There are many things which I'm not going to go in depth because we all are here to listen our great panelist. Back to Anoopji.
So with the permission of all, I would like to open the discussion, and the rules of the games are that the discussion would be in 2 rounds. In the first round, we are going to discuss the third amendment to CIRP regulations dated 13/9/2022, and the same shall be followed with the next round of discussion, which is on rainbow paper. So I request Ashish Makhija ji to come up with his presentation on these amendments. Sir, if you may please.
First of all, a very good afternoon to all the participants and all my friends. And I'm so delighted to be here. And I must thank Mr. Vinod and all other, office bearers of Persistent Insolvency Professionals Private Limited, PIPPL, as the name goes. And of course, Anoopji also is there. And I must also recognize the presence of Mr. Sanjeev Pandey, dear friend. And of course, Mr. Madan also is also a very, very dear friend. And of course, Nipun, he's also very dear friend. So I think all of us are here together to really, deliberate on this particular aspect. Well, I am the opening batsman. So let me deal with this issue. Of course, other comments will definitely come and we are going to discuss and debate it. And also implications from the banker's point of view, from the COC point of view, and from the point of view of the IPs also. I think Mr. Pandey will definitely bring in those kind of views also from the COC side, because he has been most of the time has been on the regulator side or on the COC side. And of course, as lawyers and as IPs, we will be bringing our own viewpoint out here. So friends, let me deal with this. I'll try to finish in whatever the time has been allotted to me, but not at the cost of the quality. So let's do it at a right earnest. Friends, all we are aware, we are restricting ourselves to the third amendment regulations, which was issued on 13th September 2022. We are not dealing with 16th September today because that's a longish kind of amendment. And of course, there is another webinar which has been planned for this. So friends, let us talk about the amendment which has come on 13th September. Let me share that regulation straight away on the screen so that all of us can read it together. So that will be very, very important. Now, friends, this is the regulation which we are talking about, which is 13th September 2022, third amendment regulations. Now here, what has been mentioned is that, just give me a moment. Yeah. So regulation 34B, it's a new regulation which is now being added. And the heading of 34B is fee to be paid to the IRP and resolution profession. So it speaks about both. Now, sub-regulation 1 is very clear in its term. It says that the fee which is to be paid to the IRP or the RP under regulation 33 and 34, it has to be decided by the applicant or the COC in accordance with this regulation. So now, of course, we know that under regulation 33 and 34, either the applicant decides the fees of the IRP. If he does not decide, or if the COC does not fully ratify, maybe NCLT can also decide. But only part which is ratified by the COC, well, it becomes the part of the insolvency process, because rest, of course, we know that it has to be borne by the applicant. And in the case of RP, of course, COC has the authority to decide the fees. So this was about it. But now it says that the fee will be decided in accordance with this regulation. So this is very important. So 34B becomes extremely important to that extent. Now, if we look at clause number 2, sub-regulation 2, which is there, now they have specified that now there will be a minimum fee which is to be paid to the IRP or the RP. And for this purpose, IBBI has added a schedule 2, which is mentioned there. I think everyone must have gone through it. We'll definitely go through those provisions also. So the minimum fee has now been pegged at a certain amount. Earlier, there was a doubt that, look, what will be the remuneration or what will be the fees of the IRP or the RP also. So there has to be some minimum fee. So this is the minimum fee, and higher of this fees can definitely be decided by the COC. So there is no bar in deciding the higher fee. But my worry is from the IP's point of view that probably this may become as a base, that everyone or COC will say, oh, we'll pay fees as per the table which is given in schedule number 2. So getting higher fees, obviously now the more efforts will be required on the part of the RPs to convince the COC. So I think now they will have to really, really convince that why they want higher fees than what is mentioned in the schedule. Now, friends, one of the important aspects, because many questions have been raised. Now, one of the questions which has already come to us and come to me, you see, at many forums, is whether when we talk about 34B, does it include the fee of the RP, or IRP, RP, or does it also include the fees of the IP entity? Well, friends, let me clarify at the upfront that they are talking about here in regulation 34B of the fees of the RP only, IRP or RP only. They are not talking about the fees of the IP entity. Let me clarify this. And what is the logic? Let us understand that. My friends will go to regulation 33 and 34. What they will, see there. The words which are used are very important. It says the expenses to be incurred on or by the IRP or RP. Similar words have been used in 33 and 34, both. So the word is expenses. They have not used the word fee in regulation 33 and 34. Then if you look at the explanation under 33 and 34, they have defined the word expenses. And then they say that expenses include, and the first item is fee of the IRP, RP. Second item is fee of the IPE. Third is fees of the professionals. And then the fourth item is other expenses. So explanation is common in both regulation 33 and 34. Now, what do we make out of it? And look at the words which have been used in regulation 34B. Fee to be paid. Even sub-regulation 1 says fee of the IRP. Sub-regulation 2 also says fee of the IRP. So only one component of the expenses which have been defined in regulation 33 and 34 is now to be decided by the COC. Rest of course, others also will be decided by COC. I'm not denying that, but they are not covered under this schedule. So if you have to pay a fee to the IP, that will be definitely separate. Of course, subject to the approval of the applicant and the COC. 3, the fees of the professionals you hire and other expenses also. So I think, I hope I'm clear, because I wanted to give you from where it is coming. So that's the logic, or that is the analysis which is there. Now, another important part is if you look at clause number 2. Now, from which date these provisions will apply? Now, look at this. This is extremely important, friends. The fee of the IRP or the RP. Now, the words which are used are appointed on or after 1st October 22. So, friends, underline the word appointed on or after 1st October 2022 shall not be less than the fee specified in clause 1 for the period specified in clause 2 of section 2. So, friends, when we emphasize on the word appointed on or after, so it is relatable to the appointment. It is not relatable to the CIRP. So some quarters said, oh, CIRP starting after 1st October 2022, this clause, this regulation will apply. No, it is relatable to the appointment. So let us take a case. Supposing the CIRP date is 1st August 2022. IRP appointed. Now his fees can't be in accordance with schedule number 1. But supposing on 15/9/2020, which is after these regulations, IRP is replaced with another RP and RP is appointed, then his fees can be in accordance with these schedules. It will also apply to CIRPs which have commenced prior to 1st October 2022, but the only condition is the appointment should be after, on or after 1st October. And I must also clarify that here we are not talking about appointment does not mean appointment by the COC. Please understand, in both the situations where an IRP is appointed or the RP is replaced in place of the IRP or RP is replaced. So in both the situations which are covered in section 22 and 27, the word used is there that COC will COC only merely resolves to appoint. It only decides to replace. The appointment word is used with the powers of the adjudicating authority. So the appointment of the IRP or the RP is done by the adjudicating authority, not by the COC. So if the appointment is on or after by the adjudicating authority, then of course this clause will apply. Of course, I gave an example of 15/9, so let's not take the example of 59 because in any case it talks about 1st October. So all I'm saying is that if the CIRP has begun earlier, but the IRP or RP is appointed later on after 1st October, then these regulations will definitely apply. And so date of appointment is more relevant, not the date of the CIRP. So this is one of the important aspects. Now, friends, let us come down to the third very important issue, that what is the minimum scale? Now, minimum scale is definitely given on 2 bases now. So let me show you that. So minimum fixed fee structure, which has been shown. Now they say that minimum fixed fee will be paid. Of course, it is based on the quantum of the claims admitted. So this is the word which has been used, quantum of the claims admitted. So that scale is obviously given less than 50 crore. So minimum is 1 lakh and going up to 5 lakhs, depending upon if it is more than 10,000 crore. Now, friends, here, very important. All of us know that the job of the IRP or RP is to collect the claims. These are the words which have been used in section 21, that after collating the claims, we will appoint a COC. Now, everyone, and of course, we also know that his role is not to adjudicate, but at the end of it, he has to examine, he has to verify, and at the end of the day, he has to admit also. And why that word is coming, look at this now. They are saying quantum of claims admitted. Now, admitted means, that means he has verified it and then he admits it. At the end of the day, we were all talking, no, he has no right of admission. Look at the word which has been used here. And not only here. See, this is not the first time you see the IBBI has used it. Because everyone is confused whether it has to only simply collate whatever is filed. The idea is that whatever claims are filed, he is supposed to examine it. He is supposed to verify it. And obviously, at the end of the day, he is either admitting or rejecting. So that is the intent. And if you look at regulation number 12, you go to regulation 12A, you go to regulation 13, and you also see regulation 14. Everywhere in four regulations, the word admitted is used. So therefore, the job of the RP, of course, is to admit or reject, and which is also now you can say, reinforced by these kind of a table. So it is only admission. Now, somebody very jokingly said that, look, now you see RP will keep on admitting all the claims without even verifying it, because higher the claims admitted, higher will be his fees. Well, friends, that's not the idea. I think RPs or IPs have to perform their work in a very, very professional manner. So don't be guided by this chart only that, oh, if it is more than 50 crores, I'm going to get more fees. Well, let's not get into that. We are bound by code of ethics, whether the claim is to be admitted or not, whether it is inflated claim, because I've seen in many cases, the allegations have been made in the courts also in CLTs that the inflated claims have been admitted. Penal interest and other interest at the rate of 48% and so on and so forth. So all these things have to be taken into consideration, friends. But whatever claims you admit, that's what I'm saying, professionally which are being admitted, then your fees will be decided in accordance with this. This is extremely important. Now, let us look at the other things. Now, period for the minimum fixed fee. Now, this is something which may bother some of the IPs, but I think COCs are very happy about it. Whatever fees is decided by the COC or the applicant, friends, it is from the date when you're appointed, and it will be up to a certain date. And what is that date? And that date cannot be beyond submission of the plan for approval under Section 30. We know that under Section 30, subsection 6, plan is to be filed once it is approved. So your fees is only up to that period, this minimum fees. Then submission of the application to liquidate to corporate debtor under Section 33, because SCOC can decide under 33(2). Submission of application. Now, this is also interesting. Submission of application for withdrawal under 12A. Now, here, when the word submission has been used, let us interpret it submission of an application before the adjudicating authority. Because you know that anyone who wants, applicant who wants withdrawal, he first, files an application with the IRP, and then IRP submits it to the AA. So here the word submission is with reference to submission with the adjudicating authority. So everywhere, all these three places, submission will be submission to the adjudicating authority. Because if you look at the language of Section 30, subsection 6, 33, it's the same language which is used. And of course, if the order for the closure of CIRP is made earlier, obviously you are not entitled after that. But here, the question which arises in our mind is whether the RP is entitled for a fees after this. Because if the plan is pending, you may be running the company as a going concern. You may still be handling all the compliances. You may be doing all other work like security and other things in a company. Supposing it's a real estate project or a closed factory also, you have to maintain security guards. You'll have to keep a check, and you have to do all legal compliances and tax compliances also. Like maybe you are paying them and then deducting TDS. Obviously, the jobs are involved, but your burden is reduced. That's what the advantage which has been given to COC. So they say that, look, you are entitled to the fees even after this period, these earlier of these 4 periods, but that will be decided by the COC, not on the basis of the minimum scale now. So now COC can say, okay, till the CIRP period, you will get 1 lakh rupees per month, but later on, your fees is reduced to 50,000 rupees. Well, it's up to COC to decide. So this is the disadvantage which the IPs are getting, because in earlier regime, well, they were very happy in their zone if the plan is taking 2 years time, so therefore they were drawing their entire remuneration. But here the COCs are very happy to read this, that look, they can reduce. In fact, who can object to the fees? Obviously the RAs and the COC members, because ultimately if the plan is not approved, COC has to bear it. If the plan is approved, then of course RA will bear it. So both the people are very, very happy to read this. Then the next part, which is also very, very important, is that we all had discussed that some incentives should be allowed for timely resolution, number one, and secondly, for the value maximization. So in timely resolution, again, a chart has been decided that if you do it, if you file the plan less than 165 days, then 1% of the realizable value has got a meaning, we'll deal with it. And then the slab is there. I don't have to read this. But the only thing which I want to point out is that if you file a plan beyond 330 days, then no incentive can be given for timely resolution, because the word, as it suggests, timely. So it is not timely according to IBBI, so therefore it will not be paid. The second, of course, it talks about is performance-linked incentive. So now this performance-linked incentive can also be paid to the resolution professional at the rate of 1% of the amount, by which the realizable value is higher than the liquidation value. So first percentage was on realizable value. Now you have to calculate the difference between the realizable value and liquidation value, and then of course it is to be paid. And now two more conditions which are attached to it: that approval of the adjudicating authority, that means plan has been approved, number one. Number two, and the commencement of payment to creditors. So it will be paid only on the commencement of payment of creditors by the RA. So this is one of two important conditions which are attached. Now, one question which is asked is, can an RP get both the, you can say the incentive? The answer is yes. You are entitled for both. Of course, it has to be decided by COC. One, you can get it for timely resolution, and second, for the value maximization. For calculation of 330 days, my dear friends, you are entitled to exclude the time which has been excluded. So sometimes we move an application for exclusion of time. So I believe that time has to be excluded. You will not simply do an arithmetic law. The CRP date start is this and the filing of the date is this. So number of days is 370, whereas 45 days were excluded. So therefore, you will be able to take advantage of that. Now coming to and of course, the incentive which you are getting cannot exceed more than 5 crores in any manner. That's one of the important things. So maximum is 5 crores of rupees. Now, there are two, three things which are very important to understand. One is the realizable value. I'm really surprised at the use of the word realizable value because it is going to cause huge confusion. Look at the language. It's an explanation. It says realizable value means the amount payable to the creditors in resolution plan approved under section 31. Very simple to understand that whatever is being paid to the creditors, that will be considered as a realizable value. So therefore, the CIRP cost, which is also a part of the plan, will be excluded because that is not paid to the creditors. It is not paid to the claimants. So therefore, it's very important to restrict it to the payment to the creditors. But one issue is going to come, say in a case of a home buyer. Now in a home buyer, the person who comes in as an RA, he says, I will build the flats and I will give the creditors or the home buyers the flats. So there is no realization. Rather, there is a realization from the home buyers because they will have to pay the rest of balance of the amount. And then he does the construction and hands over the flat against their claims. So can we say that the flats are also realized? Can we include the flats also in a realizable value? Well, here comes the confusion. Now, according to me, it will not be because, you see, theoretically it seems to be right, but look at the language. It means the amount payable. Now, the flat which has been given to the home buyer is not the amount payable to him. But then it also gives us another controversial issue. Like supposing, if we do not include the flats in the amount in the realizable value, that means the resolution plan value comes down. That means, supposing, let's take an example. 4,500 crores are the amount of the dues to the home buyers. Let's take a large company. And 500 crores are the other creditors. Now, out of 500 crores to the other creditors, the RA says, I'll pay 100 crores. That means 20%, 80% is the haircut. So now the total amount due was 5,000 crore. As against 5,000 crore, he's only paying 100 crores. So now can we say that the recovery in this case is 100 crores divided by 5,000 crores? That means rest was all haircut. Well, this leads us to a very dichotomous situation. So should we, because for the purposes of calculation of the haircut, naturally IBBI also includes the amount of the flats which are given to the home buyers, because that's the way we have been dealing it. But then, friends, let's understand the difference between two issues. One is realizable value. Second is resolution plan value. Now, resolution plan value will naturally include the flats which are given to the home buyers. But realizable value here, very specific meaning has been given. So means the amount payable to the creditors in the resolution plan approved. So payment is not being made to the home buyers who are being given the flats. So friends, I can caution you because this can lead to a lot of issues and you see confusions also. Of course, over a period of time, we will see that these things are taken care of. So these are the few issues which I wanted to raise to introduce. Then I'll hand it over to the organizers for further proceeding.
Thank you so much, Makija sir, for so insightful and so elaborate discussion on these amendments. And whatever question I was having for you, I think you have answered, sir. So if you may permit me to come to Sanjeev Pandey, sir, for the time being. If you may, sir, then I may proceed further.
Yeah, please go ahead.
Yes. So, Pandey, sir, I would like to ask a very simple but very interesting question. Do you see any extraordinary role for IP in this given minimum fee structure? Because most of the time what happens, this is they receive 70% or 80% out of the fee of the resolution professional RP. So how this issue is going to get addressed, especially in such CIRPs where volume of activities is very high?
Yeah, so first of all, thank you for having me here, and good afternoon, everybody. So basically, I'll share that I have a small role in this minimum fees because this suggestion went from SBI only, and we were actually concerned by the very, very low fees quoted by IPs in some of the cases. In some instances, we saw it went down up to 20,000-30,000. So we were really concerned that this is one profession or one job which is not so cheap that anybody can do it for 30,000. The price for a driver, I think, in Mumbai. So that was the concern, and we shared with IBBI that they should have some minimum fees. But this was basically, as I see it, the minimum fees of say 1 lakh for 50 crore transaction. It applies to a transaction or a CRP where the unit may be defunct, no activity, not much to do, and maybe directly we taken to liquidation. Those kind of situation I see, this fee should be there. And on top of that, whatever work is added. So basically now, whenever a professional is quoting his fees, he has to go through the scope of work. What exactly he is supposed to do. And then accordingly, he should build up on the fees. So this is the minimum he should get. On top of that, if the unit is operating, he should add some fees for that. The number of units, different units, you should add some fees, number of employees, number of litigations, all those things. I think some fees should be added so that you reach at a reasonable fees, which justifies your time, effort, your experience, and your risk in this process. So coming back to your question that you said IPs, come again, can you repeat the question?
Sir, what role do you see for IPEs? Because most of the IP, they take a cut in the fee that has been fixed for the resolution professional RP. For example,
no, I think Mr. Makija has already clarified that IPE fees will be separate from this. So the IP is not supposed to share these fees with the IP. And now
but the code does not prescribe any separate fee for that purpose, sir.
No, that is understood. See, IP is providing you some additional services which comes under the expense of the CIRP. So this is not your fees. It is something like you hire an advocate, law firm, you hire an accounting firm. Similarly, you hire an IPE to assist you in the role. And now in most of the cases, as we were seeing in SBI and in our format also, we were very clear that if you want to pay some fees to IPE, you tell us upfront. So now I see most of the cases IPE is quoting his fees separately, and IPE is also fees is quoted separately. So sir, that is not an issue.
Sir, my next question to you, since you have been part of the making of these amendments.
Okay, Anupji, I'll just interrupt here because you mentioned that the code does not provide the fees for the IPE. In fact, if you look at regulation 33 and 34, there is an explanation which is mentioned there, and it says expenses include the fees to be paid to the IRP, fee to be paid to the IPE. So even that is also included. It is mentioned in both regulation 33 and 34. I just wanted to say that. That's all.
Fine, sir. Actually, section 34B, this regulation 34B, it only relates to 33 and 34. It is not talking about other regulations. That's why I was putting this question to sir. Thank you very much, sir. For the sir, one additional question that I would like to ask to Sanjeev sir is, sir, why there is no minimum fee prescribed for bankruptcy trustees or for that purpose, the liquidators who keep on trying selling the assets for years and not able to sell the assets?
Sir, if you see my experience, this minimum fees has come almost 6 years after the promulgation of CIRP notification. So I think you should wait, and another 1 year that may also come, because this profession requires good people. That was my insistence in my bank also, and I think State Bank was behind this strategy that we should not put a highest ceiling on the fees. If you see all other professionals who deal with banks or who are empaneled with the banks, they have an upper ceiling. Like liquidator will have a maximum ceiling of say 2 lakhs for a valuer. For a lawyer, there is an upper ceiling. For any DRT case, you get so much. Similarly, other professionals. But this was specifically kept like this. And I had a small role in this, that I insisted that if you put a ceiling on this, you will not get good people in this profession. So that is how people have got fees in crores. I think Satish Gupta made some multiple crores in the SRC transaction, and banks also benefited. So now this is not a problem. This is minimum fees also only. It is for the IPs when they go to the bank to get a transaction. It is for them to convince to get a higher fees. So that is my take. So we should behave like professionals, should not compete at a cutthroat level, because this is a high risk, high reward kind of a profession. So unless you quote on the basis of your experience, your knowledge, and the risk, I'm again insisting on this point, risk, because as you see the number of actions taken against IPs, every other day you get a disciplinary order. So that kind of risk is coming with this job. Apart from that, with this new judgment, lot of onus will come on the RP, lot of litigation will continue even after the CIRP is over. So you should build those costs when you are quoting for the fees. That is my only suggestion here.
Thank you, sir. My next question is for Madan sir, GP Madan sir. Sir, I would like to ask that as the amendment prescribes minimum fee till the time of submission of application for approval of resolution plan under section 30, or submission of application to liquidator under section 33, and this withdrawal application under 12A or closure of CIRP, which is definitely by a superior court, and whichever is earlier. So event A, B, C, these are defined events, and C and D can take place where the CIRP is ordered to be closed under the orders of a superior court. So this period does not include the duration between the submission of approved plan to A and disposal of the said plan by A. Makhija sir has given some input on that, good input. But sir, sometimes the approval of plan takes years. In two of my experience, in two matters, the plan is pending for more than 2 years before the A, and they have not been able to finally adjudicate upon this. So in these scenario, and because the challenges before the resolution professional becomes too much, they have to file so many applications, avoidance application, 43 applications, 66, as well as the opposition to resolution plan, the objections to resolution plan, which is again most challenging. So in this eventuality, would you, sir, do you see that the business shall remain attractive for the resolution professional by prescribing this minimum fee, or this will impact the profession in an adverse manner?
Thank you, Anupji. Good afternoon, everybody. And it's a pleasure to be amongst all the big shots of the profession. You asked a very pertinent question, but Anupji, this regulation now prescribes for that for this period, the period from the date of filing of the application till the date of disposal of the application, this minimum fixed fee, first of all, we need to understand it's not a minimum fee, it's a minimum fixed fee. The word has been used. This minimum fixed fee shall not be applicable during this period. For this period, the IRP or RP or the liquidator, as the case may be, they have to negotiate with the committee of creditors. And I tell you, if you are going to negotiate with the committee of creditors, I'm very sure the committee of creditors will negotiate with you for a minimum possible amount. So this, according to me, this is not a welcome regulation for this period. I was addressing a webinar day before yesterday. There I suggested that this regulation should have been that this minimum fixed fee shall be for a period from the date of appointment of IRP/RP till the time of disposal of the application filed under section 30, 33 or 12A as the case may be. Why are we distinguishing between these two periods? One of the logics may be that during CIRP the work is more and after the filing of this application the work is less. But my experience says the moment the CIRP closes or the application is filed, by this time number of litigation has happened. Number of cases have started. He has to defend all these cases. He has to contest all these cases. So it's not that workload is going to be reduced. And if you read the latest amendment of 16th of September, IBBI 4th Amendment Regulations to 16th September, now it says that even after filing of this application, the COC is no more functus officio. The COC remains. A meeting of COC can also happen. So on the one hand, you are increasing the scope, you are increasing the work, and on the other hand, you are saying that for this period, the minimum fixed fee shall not be applicable. According to me, it should be till the date of disposal of the application. That's my humble view.
Thank you, sir. So I feel that though the smaller CIRP may be becoming little attractive, but it would be very difficult for a resolution professional to continue with the full capacity in the interregnum because a lot of challenges come, as you sir rightly pointed out.
He has to contest all the application. He has to safeguard the assets of the company. He has to take care of interest of the stakeholders. He has to remain a trustee. He has to keep the company as a going concern. He has to do all the compliances. He has to visit NCLT on everyday basis almost because the number of litigations are there. So, and I have another issue on this. The more clarity should have been there that what will happen if in between there is a stay from the appellate authority either on the admission order or on constitution of COC or on continuation of CIRP process or on holding of the meeting of COC, because we have seen number of orders of stay like this have been granted. What will happen to that period? And what will happen when this application actually gets quashed? Whether we will be covered under D or not? Even there is a big question mark. But certainly now you are going to have a tussle again with the committee of creditors. According to the minimum fixed fee should have been clarified in a better way. This is my submission.
Thank you so much, sir. Now my next question is to our next panelist, our Nipun Singhvi Saab. Sir, my question is related to the performance linked incentive fee for value maximization. Sir, if you see that regulation 34 subclass B subclass 3, it says may be paid, quote unquote. The similar words are used in sub-regulation 4, may be paid. So my question is whether such payments shall be paid at all, especially in view of the fact that it is the discretion of COC, and though the plans are approved or COC filed before the A within the smallest period, but A takes lot of time. So whether there shall be actual value maximization, and given the conservative approach of our financial creditors bankers, if it is their discretion and always that sword of Damocles hanging on their head in terms of showcase that why you have given extra money to X person, shall this be paid at all? Is it practical?
Thank you, Anupji, and a very good afternoon to all, esteemed panelists and my colleagues. You have rightly said that it is an option, and I think that use of the word may, even otherwise what the view has been taken, that incentive will always be dependent on the performance, the quick revival which we would be bringing out. Now, I think Makhija sir is already here, and he has appeared in one of the matter where this issue of incentive was being issued as a show cause notice by IBBI, and now they have kept silent because the matter is before Supreme Court. Now, interestingly, I suppose in that matter the amount or the quantum was of around 3 crores. And the view taken, which I could understand, is with regard to reasonability. Now here IBBI itself has come out and said that it can go up to, I think, 5 CR. So that the view which I understand is it is always an option. It will not be a matter of right that as an IP we can claim this particular amount. As far as this incentive is concerned, my view is that we should get it minutized in the COC itself on the day one, first COC, second COC, wherever it is, because I think that issue was also being deliberated by IBBI in the matter, that if it is not done during the COCs or during the CIRP period, but when the plan is getting approved, only on the last COC meeting you are getting an approval for this incentive, then there might be a question. So my suggestion is, going forward, we should always get it minutized and pass a specific resolution that this should be the amount. And I was just hearing the previous question which you had asked, and very rightly said by Madan sir that there are various issues with regard to applications, stay. So my suggestion, and what I have done in liquidation matter also, if you see, the fee is based on that 6 months and 6 months realization and everything. So what I am trying to do is, I always file an application with a specific prayer that for the purpose of calculation of fee, this particular period will be considered to be excluded. So technically speaking, suppose I have as an RP done my best and filed the resolution plan in time, but there could be legal issues where probably NCLT resends it to the COC. There could be some legal issue whereby a new bidder comes in, some irregularities is pointed out, or maybe an order of appellate forum, it again goes back to COC. My view is that we should specifically claim that that period should be excluded from the CIRP, so that we can apply purposive interpretation with regard to this table of incentive linked with the days. Also, in the first query which you had asked with regard to fixed fee, where the ambiguity is there only till submission of application, it is saying, my suggestion is, sir, as an IP, we file the application, please may ask for an interim prayer. What's wrong in it? Let NCLT decide that suppose the resolution plan is pending for 1 year, I will not be without fee. Because tomorrow what some views have been done, taken by various NCLTs, that we are functus officio, once the plan is submitted, we will not convene COC, all those issues. So my suggestion to you all is, suppose I submit the plan, what would be my fee? At least put it in the last COC, just like we put 39 ABC resolution. And suppose they do not take a call in the COC, please ask for a prayer in the application wherein the plan is pending, or maybe the liquidation order is pending. Anupji.
Thank you so much, sir. And with this, I request the permission of our distinguished panelists to move to the second limb of our discussion. We shall take question from the audience at the end.
Anupji, एक मेरी observation और है on this.
Please, sir. Please, sir.
Now it says the minimum fixed fee, after filing of this application, for the remaining period, the regulation says the fee shall be decided by the committee of creditors.
Sir.
It says it shall be decided by COC, so there is no scope of negotiation also. Suppose I was getting 3 lakhs rupees per month during CIRP, and now COC says we shall give you 50,000 rupees. And this is going to happen, take it in writing from me. This is going to happen. Whether RP will be having any option to exit at this stage. And if not, why should he be mandated? Why should he be directed to accept the fee as decided by the committee of creditors?
Correct. Balaji, I'll read it in a different manner. Basically, saying that COC will decide, that doesn't mean there's no negotiation. Only thing what changes here is the scope of work. So basically what the regulations are trying to say, that scope of work during CRP was different from once the CRP closes, you have filed the plan, then your scope of work is different. That is higher or lower, you have to convince the COCs. I think COCs will be reasonable enough to accept a reasonable fees. So it doesn't mean that they cannot negotiate. They'll have to present their case. These are my roles henceforth till the time plan is approved. And for that, I need this much minimum fees. So, and then you negotiate.
Sanjeev ji, is there any harm if these same fees continue till the time the disposal of the...
Yes, sir. The problem was that during COVID and even otherwise also, we have seen matters where the RP did not even call single COC meeting in 1 year. and he was charging fees at 5 lakh, 10 lakh. That there lies the problem. So those RPs who have called the meeting, who have done their job, fine. They are reasonable in charging the fees. People,
COVID period is over now. We can't take that example.
No, but that has given an example. And the second this thing is, some of the RPs, that is my experience, few cases, but they deliberately go for litigation to delay the CR. That has been the experience in some of the cases. I will not say many cases, some of the cases, where for every decision they have to take as an RP, they tend to depend on NCLT. Sir, you tell me what to do. NCLT is not there to take your decisions. And that application takes 3 more months. The process is delayed because this gentleman thinks I'll get additional fees for this program. All these kind of deviations can be curtailed through this.
Sir, we cannot have laws on the basis of aberrations and exceptions. These are aberrations and exceptions. On this basis, the law cannot be made, which is uniformly applicable to all.
I agree.
I think if I may interject at this stage, see, Madan sir, let us understand and appreciate why this provision has come. See, today also there is no minimum fee. Still, there is a reasonable fee which is decided by the COC, which is paid. Of course, COC can also be unreasonable today also and say, look, because there is a cutthroat competition amongst all of us. We all know that. But today I feel the COC are very reasonable and they are allowing the fee. So I don't think that there will be a immediate change that, oh, you are being paid only 25,000 rupees from henceforth. I don't think COC will be too unreasonable on this. So let's have it an experience. Otherwise, what will IBBI do later on? It'll say, okay, minimum fees will be 75% of what it is the minimum fee in the earlier period. I mean, they will come with another regulation after 1 year, if that is the situation. Anyhow, I think these are all debatable issues. Yes.
So with your permission, may I move to the next round of discussion?
Yeah, Anupji, my suggestion is subject to the other panelists also, like if audience have questions on this particular aspect, because then we'll be mixing up the two issues.
All right, sir. Sir. So is there any questions? So you may directly ask to Makija sir, Sanjeev sir, Madan sir, and Nikun sir. Audience?
I have one question and one suggestion, brother.
Please.
You see, I go with Mr. Madan. He's absolutely right, because the people like Mr. Pandey are not there in the COC. The COC people are coming who are chief manager or assistant manager, and they feel that they are the boss of everything. They consider the IP as their personal servant, and they behave like hell. And they would say that what the hell you people are doing? You are doing nothing. Everything is being done by us. Because we have made it as a default scenario. That is why you are here. They have done absolutely, and I agree with them that they have done everything because the default situation has arisen.
They have given a loan first of all.
Yes, that is the matter. But the why I'm raising this issue is because the COC people who are coming, they really are not reasonable. If they are reasonable, they would have given some money to the OCs also. They try to give not even 1% to the OCs claim. So therefore, I think a big chunk of training is required, or the people who are coming, who are being represented the banks by in COC, they should be having a mindset which in the same spirit in which you have suggested the change. The second thing is, sir, the judiciary, there is no control. Even today, I am not RP, but I am still getting the notices from NCLAT for the appeals filed after even 1 year by the OCs and others. Now, how can I pay for all those sort of things? And from whom I can claim? So these all, and IBBI is very fast in giving the disciplinary order without really finding out the problems of the IPs. They are just saying that, okay, you are not with us, so we will bloody kill you.
So, Mr. Podar, let me come in here. You see, I'll tell you, we have come a long way. You see, if you look at the BLRC, it was said that, look, it is a negotiation between the COC and the IPs. The fees will be based on that. Today, we have seen that, look, no, we want to have minimum fees. So therefore, some minimum fees has come, which is a very welcome measure. Now, What Mr. Pandey has also suggested, and I also suggest to all RPs, is that look, you have to maintain records. You may have to fight litigation even after the case is over. So you will have to inbuilt, whenever you quote your fees, you will have to, you see, load that factor also. Now, if you are simply quoting just to enter the, you see, CIRP process by quoting 50,000, 1 lakh, can you believe in one case what the person has quoted? 15,000 rupees per month. Now, can you feel that on 15,000 he can survive? So there is a cutthroat competition amongst the IPs also. So I'm saying by and large, you see, COCs have not been unreasonable. They have paid you fees of 1 crore per month also in many cases. So therefore, let's not presume or jump to conclusion. Let's let these regulations which have come, let it be stabilized. Of course, your training part, suggestion and all that, I think Mr. Pandey has already done many trainings in his own bank also, but it will definitely will take time. The law cannot be brought in for that trainings at all. So that's my take on this.
Any other question?
Yes, sir. This is Manjula, IP speaking. Sir, this, in my view, it is this change in the regulation or this addition will just apart from big forces like an average IP or a newcomer will not get more than this fee. COC will just fix to that 1 lakh and just keep quiet. This is my view, and it's going to happen like that only. Negotiation will not happen in COC. It is only that fee. COC will stick to that fees only.
Let me respond to that. So basically, madam, let me tell you, this fees or the engagement of RP is not decided on the basis of fees only. That is one thing. In SBI, we have a very detailed structure where 80% or rather 80 percentile of the credits are given on the basis of your experience, your past number of transactions completed, your domain expertise, all those things, and only 20 percentile is in respect of the fees. So even somebody is quoting 5 lakh and somebody is quoting 1 lakh, there is no guarantee that person quoting 1 lakh will get the transaction. At least for SBI, I can vouch. And many of other banks are also following the same formula. I won't say because it was created, that matrix was created by me only. And many banks are following that matrix. So it is not correct to say that just 1 lakh will be given, because fees is not only one of the criteria. 80% of the criteria are something else. And we have deliberately kept this fee criteria low because we don't want like monkeys by paying peanuts. Simple. We want genuine high caliber IPs to work for the banks, and for that we have to do. Thank you.
Anuji, a small request. I have a specific question to Sanjeev ji. Can you permit me?
Yes, please. But I think it should be the last question because I'm completing my
that's why I
yes.
taken your permission.
Yes, please.
See, sir, from this all fees pattern, what is my understanding? After reading the discussion paper on appointment of professional and all these things, in the first one page, it was so many things IBBI written on the CIRP cost. I feel this slab is for controlling the upper limit of the cost, not in fact really looking for the down cost. We all are talking about down cost, 1 lakh minimum, but my gut feeling is that for controlling the CIRP cost, maybe IBA also pressurized to get a ceiling of upper limit 5, so that further cost increase, as we stated, CIRP RP fees is 1 crore run. So they maybe wanted to get a cut short on that. This is what I feel. Is it true, sir?
No, sir, I will respond. So basically, if you read the discussion paper, they have actually mentioned not the name of the bank, but they have mentioned what we wrote to them. With those 2-3 lines of our letter are copied. So basic idea was that if somebody is quoting, as Mr. Makhija said, 15,000, then he will be doing some unscrupulous things to cover his expenses. That for discouraging that, the minimum fees is prescribed. So to encourage the IPs to be upfront, to be above board, don't do any hanky-panky. You charge your fees on the face of it. You pay GST, whatever is to be paid, but you charge your fees. Don't undercut others just by taking a transaction for 15,000 and then covering those costs from other unscrupulous means. That was the purpose of putting the minimum fees. That was our recommendation.
So with this, we are completing the first hour of our discussion and first limb of our discussion, and with the permission of our panelists, Makija sir, Madan sir, Sanjeev sir, Nipun sir, may I proceed to the next component of our discussion, sir?
Yeah, please go ahead. Please
Yes,
go ahead.
Please.
So the second limb of the discussion is the judgment of Honorable Apex Court dated 6 September 2022, passed by Honorable Justice Indira Banerjee and Honorable Justice K.S. Bopanna in civil appeal, State Tax Officer versus Rainbow Papers Limited. And I request Makija sir to give his presentation on the same, and then we will start the discussion upon the same.
Okay, so friends, I'll just share very quickly the presentation, and I'll deal with the very important parts of it. I mean, I'm not going to deal with the entire one. Of course, this will be available to you. So friends, rainbow, of course, as we always say, that is a rainbow judgment, and it is a very colorful judgment in that aspect, right? We generally say that there are many shades of gray in a law, but here there are colorful shades, you see, in rainbow papers. Well, you see, let me take you to the facts of the case very quickly. CIRP started on 12 September. Sales Tax Department, of course, attached properties of the CD after the CIRP started, that is on 8th October 2018. Then in one of the facts of the case, which is mentioned, is that on 28th of February 2018, claim was filed by the Sales Tax Department. This is the statement of the ASG for 47 crores. Of course, at some other place in the NCLAT judgment, it is written that the claim was filed after the approval of the resolution plan. So maybe we'll have to take it as it is. But at the end of the day, let's assume that it was filed, but it was filed belatedly. So that's there. Then Sales Tax Department wrote to RP to confirm the claim. That is, they wrote it on 22/10/2018. And RP wrote back, replied that, look, your entire claim has been waived off. Now, waiving off is a word which is used in the resolution plan and not at the time of the admission. So he should have been clear whether, you see, the plan has been approved. Probably he wrote like that, the plan is approved, your claim has entirely been waived off. So we're just presuming that because those facts are not mentioned here. Then naturally, Sales Tax Department then challenged the resolution plan before the adjudicating authority. Then Ahmedabad bench rejected the application as not maintainable. They said, you don't have locus. And then appeal was filed by the Sales Tax Department in NCLAT on 8th April 2019, and that appeal was also dismissed. So these are the brief facts of the case, friends. Now, what are the reasons of rejection by the NCLT? Three main primary reasons. Number one, Sales Tax Department approached the RP at a very belated stage. That is after the approval of the resolution plan. So the claim was not filed within time. Two, Sales Tax Department is not a secured creditor. So this was an argument taken before NCLAT that, look, we are the secured creditors. NCLAT rejected that argument because of Section 48 in GVAT Act, because this case involves the Gujarat Value Added Tax, where Section 48 is there. And NCLAT actually ruled that Section 48, which also starts with a non-obstant clause, cannot override Section 53, and 53 in our IBC, it also starts with a non-obstant clause. So these were the two issues which were there. I'll show you Section 48 also for your purposes. Then in this entire case, if you look at the judgment, SG and ASG have argued for Sales Tax Department. Now, while we were looking at the judgment, we could not find any arguments in opposition, whether any COC member or whether any RA argued against those, because no arguments are recorded in the judgment. So it seems to be a kind of a one-sided or an ex parte judgment to that extent, but we are not sure about it. Now, what is the ratio of the judgment? Let's understand the ratio of the judgment here. Number one, the judge says, and very, very, you see, in a very, you can say in a sweeping statement, timelines in IBC are directory. So here the judges are not talking about the regulation. In fact, the issue before them was Regulation 12. If a claim is filed beyond 90 days time limit, which is mentioned in Regulation 12, whether that time limit is directory or mandatory, probably they were only concerned about it. But this is a very, very general statement which has been made that timelines in IBC are directory. Now, by the one stroke of pen, even the timelines in code have been made a directory. Well, I will not look at it that way because I will restrict to the facts of the case, but this is a sweeping statement which can probably be used by someone later on that, look, all the timelines are there. Secondly, the judges say that sales tax department was not required to file the claim. Now, from where they are coming from? Now, this is very important for my friends to understand. The judges have relied upon Regulation 12. Now, Regulation 12, and that too unamended regulation. If you look at the unamended regulation, the regulations were amended from 3rd July 2018. Prior to that, there was a separate word which was used. It said that submission of proof of claim. In fact, the heading still says so. And in Regulation 12.1 and 12.2, they are saying that RP should submit the creditor should submit the proof of claim. So they have come to this conclusion that claim was not required to be filed. It was only the proof of claim which was required to be filed. Now, later on 3rd July 2018, the regulations were amended to say now claim with proof. So earlier the words were proof of claim. They were replaced with claim with proof. So they have actually recognized that, look, the regulations have been amended later on. So now you have to file the claim with proof. But earlier you were only supposed to file the proof of claim if asked for. So they have come to the conclusion that, look, as per the books of account, some liability of sales tax was appearing. RP was supposed to recognize it. And if he was not happy, probably he should have asked for the proof of claim, which he never asked for. Well, according to me, this logic does not still cut ties because of the other regulations, because you can't read a regulation in isolation. You have to read regulation starting from Regulation 8, 9, 9A, 10. All these regulations talk about filing of the claim, isn't it? So if the claim is supposed to be filed, then where is the question of not sales tax department not filing the claim? But be that as it may, this was the logic which was adopted. So here, friends, for all times to come, we don't have to presume that sales tax department or government authorities are not required to file claim. That's not the case. In any case, the amendment has already come on 3/7/18. Even if we presume that, then the claims have to be filed with proof. So therefore, let's not presume that for all times to come, sales tax department or other departments are not supposed to file it. Third, obviously, this is also one of the judgments. They say RP failed to include the claim amount as per the books of account in the information memorandum. Well, friends, in the information memorandum, now, of course, on 16 September, the new 4th amendment has already come, which we are not discussing today, but there is a specific clause now that, look, if you are preparing an information memorandum, what is the position of the creditors as per the books of account, you have to include in information memorandum. So probably this was also coming not because of this judgment, but because of earlier judgments also, KV developers judgment, which was given by NCLAT, which said the claims of the home buyers who have not filed the claim, which should also be a part of the information memorandum. So this was the whole thought process which has been there. But this is not a very big issue. Probably most of us were already doing this. Now, this is something which is serious. Sales tax department is a secured creditor. Now, the bench has analyzed section 3, subsection 30 and 31, clause 31 of IBC to come to a conclusion that sales tax department is a secured creditor. Now, this is one of the serious issues which actually affect the COC members, particularly the secured financial creditors. Now, and the second thing which is relevant is the judges also say that section 53 of IBC does not override section 48, and neither 48 overrides 53, because they say both of them, you see, are operating in their own spheres. So they say there is no inconsistency, and therefore no one section overrides the other section. So we'll deal with it in a little while. And third, which is a very important, observation, or rather I would say ratio, security interest could be created by operation of law. So security interest, I'll show you the definition in a little while. This is a secured creditor and security interest definition in our IBC. Secured creditor is a very simple definition, means a creditor in whose favor the security interest is created. Then security interest, friends, it's a very, very, you can say a long definition and a very broad one. Means, so it is divided into two parts, one meaning part and second is inclusive part. In meaning part, it says right, title, interest, or claim to property, which is created in favor of a secured creditor by transaction which secures payment or performance on obligation. So this is a very specific thing, which means that it is by a contract. So by a contractual arrangement, by a transaction, which can happen only by a transaction can happen only by way of a contract. So contractual rights or titles which are created in favor of a secured creditor. But then the next sentence says includes. Now that is inclusive definition. And it says mortgage charge. Now look at the word charge. And charge can be created by the action of the company through a contract when you enter into an agreement with a bank or any other financial creditor, or you can have it by operation of law. So here the logic of the bench is coming is that look, even by operation of law, a charge can be created, and once a charge is created, they are having a security interest. If they have a security interest, then that department becomes the secured creditor. So this is the whole logic which is coming from. Now let us look at Section 48. What actually persuaded the bench to deal with this? This is Section 48 of Gujarat Value Added Tax Act. 48 says tax to be the first charge on property. And friends, I must clarify this. This was there in Bombay Sales Tax Act also. This was there in all state acts. This is not a new thing which we are seeing today. It is happening since 1970, 80, 90s. All acts say this. Notwithstanding anything to the contrary contained in any law for the time being in force, any amount payable by a dealer or by any other person. Now look at the next words. On account of tax, interest, or penalty. All the three things are included. For which he is liable to pay to the government, it shall be a first charge on the property of such dealer, or as the case may be, such person. So friends, the words are very, very clear. It talks about a security interest, because security interest is a later word. When SEBI was formed, then security interest was used. Earlier, security interest was not being used. Earlier, we were talking about charge, creation, mortgage, and other things. First charge. So here the GVAT Act says that tax, interest, or penalty, if due from a company or a dealer, then it shall be a first charge on the property. That means property means the entire property of the dealer. So this is what it is. Now let's look at Section 53. Why the judges say that 53, you see, does not override 48. This is the reason. 53 says that notwithstanding anything to the contrary contained in any law enacted by a parliament or state legislature for the time being in force, proceeds from the sale of liquidation assets to be distributed in following order of priority. So friends, Section 53 deals with distribution of the assets and the order of priority. It does not deal with who is a secured creditor, who is not. So therefore, the Supreme Court said, look, 53 operates in a different sphere. 48 is only talking about whether I have a security interest or not. So they said there is no clash, there is no inconsistency. And to that extent, friends, I fully agree with that judgment, because otherwise we all know that a Sales Tax Act, which is a state act, cannot override a central act. We all know that. I think we don't require a rocket science or any Supreme Court judgment for that purposes. Now we are all aware. Article 254 of the Constitution of India, where the list 1, list 2, and then a concurrent list is also there. So all those entries which are there, which we have to see. Now look at this. Now another phase. We have GST now. Section 82 of the GST also is worded in a similar manner, but with a slight change. And what is the impact of that? We'll have to really debate and discuss that. It also says, notwithstanding anything to the contrary contained in any other law for the time being in force, but then it says, save as otherwise provided in the IBC. Now these words, these words were missing in GVAT. Obviously, because GVAT Act was much older, and by that time IBC was not there. Any amount payable by a taxable person or any other person on account of tax, interest, or penalty, which is liable to pay to the government, shall be the first charge on the property of such taxable person. So it becomes a first charge. But it says, save as otherwise provided in IBC. Now, looking from this angle, what is provided in IBC? In IBC, what is provided is the order of priority. And in order of priority, the payment of government dues. They have not distinguished between secured and unsecured government dues. They say they will be paid at slab number 5, at a 5th level, lower than the secured creditors, lower than the unsecured financial creditors also, at a 5th level. So now one question could be whether the word government dues, which is mentioned in slab number 5, level 5, will include both secured and unsecured. Well, that's a big question, and we'll have to really deal with that. So let us deal it, you see, in that manner. But before that, you see, there is one more aspect which I want to bring in here. Section 77, subsection 3 of the Companies Act. It was amended after the IBC also. What does it say? It says, notwithstanding anything contained in any other law for the time being in force, no charge created by a company, underline the words, friends, created by a company, shall be taken into account by the liquidator appointed under this act or under IBC. So these under IBC was added later on, as the case may be, or any other creditor, unless it is duly registered under subsection 1 and a certificate of registration has been issued by the registrar under subsection 2. So we all know that a charge is required to be filed with the ROC, and ROC is supposed to issue a certificate of registration, and only those charges are recognized and considered, have to be considered by the liquidator, because otherwise a liquidator shall not take into account. That means that person will be considered as unsecured creditor if this charge is not registered with the registrar of companies. Now, in the case of sales tax department, it is a statutory charge. Now, should that charge also be registered? And if it is not registered, what is going to be the fate of that, whether they will be treated as unsecured? This aspect has not been considered. Of course, this logic, this part has not been discussed in this judgment. We are discussing it because it is going to flow over a period of time. But look at the words. Somebody can argue. Of course, there can be two sides of arguments. The words which are used is no charge created by a company. Now, statutory charge is not created by a company. It is created by a statute. So will this 77(3) will cover the statutory charge also or not? That's a big question which we have to answer. I'll come to, you see, the intent of the law and all that. That, of course, is there. Going back to the preamble, friends, going back to the preamble, let's stay here. Going back to the preamble and also BLRC. Of course, what BLRC says now probably is not very relevant, because a lot of issues have changed and a lot of jurisprudence has changed. And in fact, a lot of amendments have also come in. So I will not really rely upon BLRC at this stage. But yes, and so far as understanding the intent or understanding the concept, it is important. But in the preamble, what is mentioned? If you look at the preamble carefully, it says alteration in the order of priority of payment of the government dues. Now, what was the meaning of this? Why the government wanted an alteration? Because we had the Companies Act, winding up provisions were there, order of priority was already mentioned there, and there the government dues were actually at the crown debts were considered over and above, and therefore overriding preferential payment section 529A was brought in. Under 529, government dues were given the top priority, but then when 529A was brought in, it said secured creditors, and of course the workman pro rata proportionate dues will be there. So, and most of the judgments say that, look, whether the statutory, there are a lot of judgments in Companies Act. It's not something which is new, which has come right now. But at the end of the day, what the government wanted, that the government dues now should be at a lower level. They brought it at level number 5, even after the unsecured financial creditors. If you look at section 53, now clause number D says unsecured financial creditors. So what was the purpose? The purpose was that government dues, whether secured or unsecured, should be given at a lower priority. Crown debt should be given lower. But nobody thought, probably there is an error in drafting and not an error in understanding. Now, what is the error in drafting? The error in drafting is coming from section 53, subsection 1, and clause number B, and then subclause 2. 53, 1B, 2. If you read that, it says the payment should be made in priority to secured creditors. Now, under IBC, we have distinguished between financial and operational creditors. We all know government is an operational creditor. There is no quarrel. But even operational creditor can also be secured. So if you use only the word secured creditor in 53(1)(b)(2), will it include secured operational creditors also or not? The answer is yes, because of the defect in the language. Because if you go to D, it says unsecured financial creditor. Now, why you have brought in financial creditor unsecured? Because you wanted to categorize that you want to pay even financial creditors who are unsecured over and above the operational creditors, over and above the government dues also. So having brought that distinction there, but not brought in secured creditors. So what I had suggested in many forums also, and once again I suggest that, look, whether review or no review, whatever may happen in this judgment, I think we should not wait for that. My suggestion to the government, in order to protect the interest of the financial institutions or banks, is that in 53(1)(b)(2), please make it specific and say secured financial creditor. Add the word financial between secured and creditor. I think the whole controversy will go away. Now, but this brings to another dichotomy. And what is that dichotomy? Let me explain. Supposing there are no financial creditor in a company. There is a operational creditor. There are, say, 5 operational creditors, and 1 is a secured operational creditor. Now, do you think all operational creditors should be paid in proportion, or should the secured operational creditor be paid earlier? The answer is yes. If somebody is secured, obviously he has to be paid earlier. So but if you want to peg them lower than the secured financial creditor, then probably the government needs to add another line in between, say clause number CA in 53(1) CA, and they should say secured operational creditors except government dues. And in clause number E, which is government dues, they should again give a clarification. If they want to bring secured and unsecured both at this stage, then they should say government dues, whether secured or unsecured. I think these 3 amendments will clarify the whole doubt. It will put at rest the entire controversy. Of course, there is another controversy of, inter se agreements between the banks, like first charge, second charge holder, because in 53, there is no clarity. Of course, there was a recommendation by the Insolvency Law Committee in 2020, but no amendment has come, because they suggested that one clarification or explanation be added in section 53. So that may come, that we don't know. But that is also required. So these 3 amendments, I think, will put at rest the entire controversy. 1, secured financial creditor. Then clause number CA, specially added, secured operational creditors, whether including government, not including, that is up to the government. And then E, if they only want, if they want both secured and unsecured here, then they must clarify whether secured or unsecured in clause number E, which probably I also feel was the intent originally also, that the crown debt should be lower than the financial debts, whether secured or unsecured. And of course, operational creditors, if they are secured, they have to be paid earlier. There is no quarrel or fight on this. Now let us look at what are the other ratios. They say Regulation 12 is directory and not mandatory. I think this has been held earlier also by many NCLT and CLAT benches also. I don't think, we need any discussion on that. Regulation 12 is definitely held to be mandatory. One can file after 90 days also, and NCLTs have been very liberal in condoning the delays. So I don't think we'll need to debate on this. Then another aspect which has been mentioned is that adjudicating authority must examine compliance to section 32. Well, whether said or not, this has to be followed. I believe it was not required, but specifically said there 41, 43 in para 41, 43, that's fine. So, but I don't think we need to really, there is any quarrel that 32 compliances have to be seen. Now, let us look at, but they say that, look, if any plan which is approved in violation of section 32, then such plan will not bind the state when there are outstanding statutory rules. I think that's all right. If the plan is not approved, is approved in contravention of section 32, obviously it will not bind anyone. So we all know that. So I don't think we'll have to debate on this, and shall and may and all those, I can just skip that. I just want to restrict myself to next 3 slides. Para 52, 53, 54 of the judgment. Friends, these are very, very dangerous statements. And I think there is a warning to COC also, warning to the financial creditors also in one of the paras. And that is in para 54. I'll just show you in a little while. If the resolution plan ignores the statutory demands payable to any state government or a legal authority altogether, the A is bound to reject the plan. Now, this is a sweeping statement. They say that, look, if there is a state government or a local authority due is there, and if your plan says 100% haircut, then the A is bound to reject the plan. And in any case, you see, recently, I think 3 days on 12th of September, I think day before yesterday, 1 week back, a plan has been approved by NCLT Delhi bench. And in that bench is a home buyer's case. The NCLT New Delhi bench says, insofar as the statutory dues are concerned, we are not giving any concession. It is up to the statutory authorities to do that. Now, what is the meaning of this? Now, the poor RA who wants these concessions, because otherwise he will have to bring in more money now. Now, he is not given any exit route. But it is the dictum now that, look, statutory authorities will consider your reliefs or claims or concessions. If you are not giving a relief, then give him an opportunity to RA to exit. Now today, that poor fellow, supposing 50 crores rupees he has to pay to the statutory authorities, then where he's left with? He's a businessman. He's there out to make money. He's not doing charity just to run a company as a going concern. I think we are missing the point at some places. So NCLTs, we know that everyone is going in its own way. And ultimately, we want all judgments to be passed by Supreme Court, which is not possible, actually. But anyhow, this is a very, very sweeping statement, which I believe should have been restricted. If the bench wanted to make the statement, they should have restricted only to state government, because that was the issue. What was the need to say legal authority? Now, legal authority will include now municipal corporations also. Now, this is something which is not required at all, that according to me. And look at para 53, friends. Now, para 53 is more dangerous. It says if the company is unable to pay its debts, which includes statutory dues to the government or local authority, again, the local authority word has come, and there is no plan which contemplates dissipation of those debts in a phased manner, which means, in other words, uniform proportional reduction, then the company would necessarily have to be liquidated and its assets so distributed under Section 53. Wow. Let's try to understand. If there are statutory dues like sales tax dues are there, obviously, I would say they must be secured first. If they are unsecured state dues, well, whether this statement will apply, I don't think it should apply, because we must look into the text and context must match. Now, what judges say? Dissipation of those debts in a phased manner. That means uniform proportional reduction. Dissipation means liquidation. You must liquidate, you must pay. They say the payment must be made to the statutory dues in a uniform proportional reduction manner. So what you are paying to the bank, supposing banks are getting a haircut of say 50%. So statutory dues should also get 50%, not more than that. Now, we always knew, and there has been a jurisprudence, commercial wisdom of the COC, that the distribution by the COC falls within the commercial wisdom. Obviously, they keep a major chunk to themselves, but probably somebody said they have been very unfair to operational creditors, paying 1%, 2%, or maximum 5% in many cases. But at the end of the day, friends, let's understand. If the company goes into liquidation, who gets the money? Why do we say that COCs are being unfair? At the end of the day, at least they're saying that, okay, pay some money to the operational creditors. Because if the company goes into liquidation, finally, operational creditors are not going to get a single penny in most of the cases. So therefore, let's not put blame squarely on that to the COC members only. Of course, over a period of time, they will also have to realize that, look, they will have, because it's a going concern, they will have to make some money or pay some money. Otherwise, that poor fellow operational creditor will come into CIRP, and ultimately their loans will go bad once they do that. So anyhow, those things apart, but this is a serious statement. If there is no uniform proportional reduction, then the company has to be liquidated. That's what they say. And today, you see, in every court, they are asking, even as recently as NCLT Chandigarh bench has also asked for filing of a affidavit that whether rainbow paper applies to you or not. And if you are distinguishing, how you are distinguished. So every bench has started asking this question today, even in NCLAT also. Wherever you go, they say, okay, please tell us whether rainbow applies to you or not. So all the pending plans which are there, I think they are being hit by rainbow papers now. So, but I'll also tell you how to make a distinction, but let us understand the last clause, and then we will go and start discussing. The COC, which consists of financial creditors, cannot secure. Now, this is a warning to COC. This is a serious para. The COC, which consists of financial creditors, cannot secure their own dues at the cost of statutory dues owed to any government or government authority, or for that matter, any other dues. Wow. We had only sales tax dues which are there as a subject matter. So it goes beyond to any government. That means state government, central government, government authority, and then the last sentence says, or for that matter, any other dues. So will that any other dues include also the operational creditors now? So it's a straight warning to the COC, my dear friends. That's a look, you cannot keep major chunk with you and not paying to the other dues. Well, the IBC itself says you have to be fair and transparent, no doubt about it. But this is a serious statement. Probably the COCs will definitely be concerned about it. And if nobody else goes, at least COC should file a review petition against this particular para only. That's my view, because this will not be covered by any amendment in law. So this has to be a thing which you must talk about it and see that this is taken care of. Now, friends, one last statement before I leave the forum open for discussion is this. Now, what is the logic? Let's try to understand. One, sales tax department was held to be a secured creditor because of one reason, because there was section 48. And by operation of law, they said, yes, you are secured creditor. That's one. Now, where is the question of parity coming in? Parity came because of section 53 1B language, which is there. Because the word is only secured creditor. It does not distinguish between secured operational and secured financial creditor. So the Supreme Court did not say they are secured financial creditor. They said they are operational creditor, but they are secured operational creditor. And now why they said the section 32 was not complied with, I'll just explain very quickly. Section 32B protects operational creditors and also dissenting financial creditors with some minimum payment. We all understand that. And there are three limits insofar as operational creditors are concerned. We have to compare three limits. One, what is the amount being paid in resolution plan? It will be compared with resolution plan value if distributed in accordance with section 53, what they are going to get. Three, liquidation value if distributed in accordance with resolution, in accordance with section 53. So higher of these three limits, they are entitled. Now, in case they are treated as secured creditor, they will fall, according to the Supreme Court, they fall under 53 1B2. So therefore, they were entitled to some liquidation value because it has to be distributed in proportional reduction manner. That is what their uniform reduction manner. So therefore, the Supreme Court said, your plan is bad in law. So therefore, they rejected this plan. So this was the whole thought process which was there. Well, I leave it to the organizers for, discussions and questions.
Thank you so much, Makhija sir, for so elaborate and insightful views on the judgment. I request GP Madan sir to throw some light on this judgment. Sir, my question, there is one question from my side. As I was listening, Makhija sir, sir is actually trying to say that certain amendments are required. Sir, if you see, Makhija sir, section subclass 3, subclass 30 defines secured creditor, and it says it means a creditor in favor of whom security interest is created. And if you see the next section 3, subclass 3(1), security interest, rights, title, interest, claim, etc., created in favor of the secured creditor. So the word creditor, can these government departments can come into the definition of creditor, because unless they become a creditor, they cannot be secured creditor, and unless they are creditor and secured creditor, they cannot get any security interest in their favor. So what do you say on this, sir?
Okay, Anupji, I believe this question is directed to me. Well, you see, we have to read the full definition. We are reading only one part of it. I mentioned in my deliberation also that if you read 331, it has got two parts. One, it is a meaning part. Second is inclusive part. So what you are reading is, you are right to the extent when you read meaning part. But then it says includes mortgage charge. Now charge is included. So charge can be created through contract or it can be created by operation of law. So I think this is because all of us know as lawyers that when the word includes is used, the definition is exhaustive, right? The definition is not exhaustive. It is illustrative only. So rather it is only giving illustrations, mortgage, charge, anything else can also be included. So according to me, it falls within the word charge and not in the meaning definition.
Sir, I'm on little different point. Unless and until I'm a creditor, how can I be a secured creditor? And how can that security interest be created in my favor? Or the charge may be
No, Anupji, please tell me whether sales tax dues which are due to sales tax department, are they creditors or not?
Sir, to my
creditor, whether they have filed a claim or not, that's a separate issue, right? Well, that of course they said that look, he should have taken the considered their claim as per the books of account, not gone into that detail because they were not supposed to file the claim. So that is a separate aspect. But at the end of the day, they are creditors. And in contingent liabilities or in any other books of accounts, sales tax dues must be appearing. Some dues must be appearing. So I don't think they are not creditors. I don't agree with that. Okay. Yes.
Madan sir, what do you say on this?
Yes, Anupji, you are asking me?
Yes, sir. Your expert views on the judgment.
My views on the judgment?
Yes, overall.
Makhija ji ke baad ab kisi se pucho views on the judgment, so this is not in the right spirit.
Sir, we are in the process of discussion, and I'm sure that you are having extraordinary views on the judgment.
Okay, like first of all, whatever Mr. Makhija said, I'll say ditto. Those are my views. In addition to that, some of my observations on this judgment, Makhija ji beautifully said in the beginning, and he has some rainbow, also very colorful rainbow in the first slide of his PPT. But I call it clouds over IBC. And rather I'll say black clouds over IBC, this judgment. It's not rainbow, name of the case is rainbow, but it's a black cloud. So according to me, this judgment needs to be reviewed immediately, and till the time it is reviewed, this operation of this judgment should be stayed. I'm sorry to give such a sweeping statement, but I'm giving it. Because this is what my observation is. Next is, it is going to create trouble for all those resolution plans now which are pending before the committee of creditors for approval or before the adjudicating authority for approval. And thirdly, even on those plans which are under implementation, now the government authorities may come forward and they file their applications and challenge the approval of those plans. Nobody can stop anybody to file an application or appeal or a petition. Everybody is allowed. That's a legal right and they can do that. Another issue on this is, now the judgment says that statutory dues should be considered by the IRP or RP or the liquidator as the case may be. Now, what should be the quantum of these dues? Whether the quantum as per the books of accounts of the corporate debtor or as per the records of the government authority. What is that amount which should be considered in IM or in the resolution plan? No clarity on that has been provided. My next submission is that in this case, the Honorable SG and ASG both have actually supported GVAT rather than supporting the Insolvency and Bankruptcy Code. In my view, they should have supported IBC rather than supporting GVAT. Some of the participants in the earlier webinars have asked a question on the applicability of Section 238. Let me tell you that Section 238 has not at all been considered in this judgment. And according to Section 238 is not applicable also, because Section 238 becomes applicable only when there is inconsistency. As far as inconsistency, there is no inconsistency between this judgment and the code. The only thing is that on what basis they have been considered as secured creditor without having any charge or without having any registration of charge. Another sweeping statement which has been given in this judgment is, I think Mr. Makhija also highlighted that all timelines under the code are directory in nature. Earlier, we used to see some of the orders or judgment that regulation number so and so is directory, or the timeline under section 7 or 9 is directory in nature. But this judgment says all timelines under the code are directory in nature. Now, suppose tomorrow, if an insolvency professional does not adhere to the timelines under the code or the regulations, and if he receives a show cause notice from the regulator, he can always very clearly say that here's the judgment of Honorable Supreme Court, which says that all timelines are directory in nature. So even though I have not complied with that, there is no non-compliance of the code or the regulations. Last but not the least, the observation from my side is the impact of this judgment. You know, Section 10 is already thing of the past. Section 10 applications, the adjudicating authority is not welcoming Section 10 applications. Number of filing of Section 9 applications is also reduced because of the limit from 1 lakh to 1 crore. Hardly any Section 9 application is being filed or preferred. Under Section 7, the real estate applications are almost nil nowadays, the fresh applications, because of the 10% or 1/10 of the total number of allottees in that particular project. The only applications, the fresh applications which are surviving are by the financial creditors, may the banks or financial institution or NBFC. Now, because of this judgment, I don't think that banks or NBFCs will come forward and will file the Section 7 application. Is it going to show a closer door to Section 2 IBC? I'm having my own apprehension, and I will say yes. Unless this order is reviewed, this judgment is reviewed and a stay is granted or a clarity is provided on this, I don't think the banks, I think Mr. Sanjeev Pandey will also give his valuable views. I don't think the banks will come forward till that time this judgment survives. Thank you.
Sanjeev sir, your views please on this, because I do feel the same that if the judgment remains as it is, the NCLTs are going to become new DRTs. The way we are not so satisfied with the performance, the similar is going to happen with National Company Law Tribunals, because there will be no certainty in the resolution plans. Nobody shall be interested to become RA in this, because never know what would be the budgetary considerations, what would be the size of the plan, how much money he is going to shell after the judgment. So what is your opinion on that, sir? Sir, you are on mute. Sir, you are on mute.
Yeah, sorry. So basically, I'll share my experience in IBBI when we were drafting the regulations. And when we saw the provisions of the code and the strength of provisions, so we used to discuss with Dr. Sahu at that time. Yes, sir, how long this code will survive? So that was the main concern, because we were apprehensive that this code will not survive more than 1 year. That was our estimate at that time, because the way it was taking away the control from the promoters and all the other very strong provisions, we thought that some High Court or Supreme Court will pass on a stay and kill this code. To our surprise, basically, it has survived more than 5 years. Now it is almost on the verge of completing 6 years. But this judgment came as a surprise, because all through the Supreme Court has been standing behind the code very strongly. When SR Steel, people were very, very hopeful, especially the borrower class, that SR Steel, if the falls against the banks, then the code is over. But then even in SR Steel, and if you look at the NCLT and NCLT judgments in SR Steel, so there was a lot of hopelessness if this code is going the DRT or SARFAESI way. But somehow the SR Steel judgment came as a landmark and saved the day for the court. But suddenly this brings a surprise for everybody. And I'm totally in agreement with both my seniors, like Mr. Makija and Mr. Madan, prominent lawyers and experts on this subject. So they have threadbare analyzed each of the things. So I don't have much to add on that. Only thing I will say is that there has been attempts during last 5 to 6 years where the NCLTs have tried to encroach upon the powers of COC, multiple judgments. And those were resisted by Supreme Court, especially in the area of this directory nature of timelines, then the powers of COC to decide on distribution, so many matters. So actually the executive authority tried to take away that commercial wisdom or commercial powers away from COC. But Supreme Court stood behind. They say, no, nothing doing. You have to stick to your section 30 bracket 2 and 31, whatever is within your powers. Don't peep into resolution plan or the distribution. That is the domain of COC. But this particular judgment has opened that Pandora's box also. So now whatever COC decides is open to scrutiny, open to litigation, and this will put a death knell on the resolution plans and resolution applicants basically. I think after this judgment, not many applicants will venture out. Already very few were coming. If you look at the track record in last 5 years, already 80% of the cases were going into liquidation in any case. But somehow IBBI was justifying that most of these cases were already BFR cases or defunct cases. But point is not that. Point is that how any law, the test of any insolvency law is that how vibrant market it creates, or vibrant market for stress assets it creates. But if you see till the SR Steel judgment, there was a euphoria. In initial 1-2 years, even when I was in IBBI, I used to entertain many delegations from China, Hong Kong, different countries. They wanted to understand IBC. Today, I don't see many foreign investors or foreign funds coming in and looking for good assets in IBC. Even domestic applicants will be very, very worried and won't be inclined to offer resolution plan. Your plan will never be final after this. Plan will always be open to litigation, open to scrutiny and then unraveling. And especially when they said in a very sweeping statement that the statutory authority need not file a claim, then they can come in, their claim will stay forever, they will be only reduced in a systematic manner. All those things go against the very basic preamble of the code, basic fundamental, and whatever we have learned in last 5 years. My sense is this judgment goes directly against that. So unless either the law is revised or this judgment is withdrawn or sent to a larger bench for a proper review, this is a serious threat to IBC. That is all I have to say. Thank you.
Thank you, sir. My next question is to our beloved Nipun Sanghvi Saab. Sir, what are the missing links in this judgment according to you, and how do you feel same can be plugged? By way of a review petition, by somebody who is not a party to that petition, or trying to get it referred to a larger bench? How can it be done? Because the understanding is that there is something very serious which is going to impact entire insolvency jurisprudence in the country, and the system which is now less attractive shall become least attractive if the judgment remains. So what is your expert opinion on the same, sir?
First of all, let me tell you that we have been fighting with Gujarat VAT in almost all the resolution plans approved here in NCLT Ahmedabad. What was happening is that previously in one of the matters, Gujarat High Court had granted them status quo with regard to the secured creditor issue. And it was already going on for more than 3 years. Now, the matter which was status quo granted by Gujarat High Court, and then the matter ultimately went to Supreme Court, every time the department used to file application in all the resolution plan, whichever we got approved. In fact, even in SR Steel, Pandey sir must be recollecting, because I was part of SR Steel also. There also Gujarat VAT came, and if I am not wrong, somewhere around 10,000 crore rupees is the amount due of SR. So just if we reverse the situation and bring this to SR, you can understand the impact of 10,000 CR on the total resolution plan. So I suppose it's going to be a very dangerous issue if it is implemented in the fashion in which this order is given. Secondly, what has happened is many of times when in the liquidation we were selling the properties here what they do is there is also one section 45 of GVAT Act. So what Gujarat VAT department was doing, they were putting a charge on the land revenue records. So Makhija sir has rightly said that there is an amendment in the Companies Act and they should have got a registration of charge in the ROC, but it was not happening. But when we used to sell or give a sale deed during the liquidation, 712 land revenue records. We call it here 7-12 ka utara in Gujarati. So 712 revenue records would always be a problem, and we used to keep on fighting. And recently, Gujarat High Court, in one of my matters of Alpesh Gems, had opined that this will not work, only claim has to be filed and you will be treated as an operational creditor. And clearly the government dues which we used to talk at 5th level was there. So already Gujarat High Court had ruled in the favor of insolvency. But this judgment comes as a surprise because all the plans are going to be hit by it. After this judgment, I can tell you what is happening here. As far as Gujarat VAT is concerned, they have moved an application in almost all the matters where the distribution is pending or implementation is going on. And in one of my matter where the distribution was pending and we had taken an undertaking from all the bankers, now they have made all bankers as a party in the application and said that the concept of restitution should apply and there should be a redistribution of the amount. So this is going to be very dangerous if this judgment is implemented in this fashion. Now, some of the points for thought which I think should be there deliberated by all the panelists. My view is that Ghanshyam Mishra judgment, which specifically talks about the timelines, the sales tax department, was and is a 3-member bench judgment. This particular judgment, Rainbow Papers, is only of 2-member or 2 judges. So in my view, because it does not consider Ghanshyam Mishra, this judgment can be said to be per incurium. So that is my,
Yes, that's right.
that is one of my thought on this particular judgment. Though from sources and from the COC members, one of the members who I am talked about that they are already moving for review. And in fact, IBBI has also seriously come out with that circular that now all the matters where virus is challenged, you have to inform the matter to IBBI, whether it is pending in High Court or Supreme Court, because IBBI was also not a party in this particular matter. And just to give you a factual background why this happened and why respondents were practically not represented, the reason was this, that the plan which was submitted by the resolution applicant, that was Kushal Limited, also a listed company, basically the resolution plan was of merger. So Rainbow Paper as such does not exist today. It has already been merged in Kushal Limited. Now Kushal Limited was not able to implement the plan because they could not fulfill the payment terms. So they had already, the COC had already moved a liquidation application which is pending as on date with the NCLT Ahmedabad. And they had tried to withdraw the plan, citing some of the issues of information memorandum and capacity and some theft issues. That also was rejected by NCLT and thereby NCLAT. So factually speaking, now the liquidation application is pending. Now the worry to the COC members in this particular case is, suppose they want to go for liquidation, whether this judgment will hit them in liquidation or not. I think Pandey sir and we were discussing few days back after this judgment that under SARFISI, there is a section called 26 capital E, which was also introduced when IBC was introduced in 2016. Now that's 26E categorically says that priority will be of bankers, priority will be of financial creditors over the tax dues. And that has been regularly upheld even in various high courts and Supreme Court. So and all the COC members now, if this judgment is used for redistribution or maybe restitution logic, then they will always prefer to go under liquidation and take away their asset under section 52. So this particular issue of liquidation over resolution is going to be in play if this judgment is immediately not stayed or may not be set aside. However, my suggestion and how I am pleading all the plans pending in this particular NCLT is that we are saying that at least wait, because in my view, this is a per incurium judgment, does not take into consideration the Ghanshyam Mishra view. And also one important aspect which I would like to highlight in the last para, Supreme Court says that resolution plan is set aside. In my view, assuming that this judgment is correct and it is a secured creditor, even then, plan should not have been set aside. Only the distribution part could have been set aside. So setting aside the plan means that you are giving a new entry to all the COC members or the RA whether to resolve the company or to liquidate the company. So that is again, I think, something which is very damaging in scenario of revival, because ultimately if you read BLRC or maybe amendments from time to time, IBC is nothing but an improvement over SARFAESI law, and SARFAESI was an improvement over RDDB. So it was basically with an objective that the banks are able to get money and to recover money, maybe through resolution. Now, if that particular objective itself is set aside, then I think this particular judgment will have far-reaching effect, maybe a death nail on IBC.
My next, anything else, sir?
One more point and one more loophole, which I think has not been discussed in this particular judgment. When I was just reading that IBC and GST came in parallelly. Now GST has subsumed Gujarat VAT Act and all the state VAT acts. There is no quarrel, no controversy on that part. Now, if the GST Act, which has subsumed Gujarat VAT Act itself, is giving priority to IBC, or IBC is supreme over GST, then I think in wildest dream, it cannot be the logic of legislature to give pre-GST priority to Gujarat VAT. So that's my view on this particular object of pre-GST. At the best, this judgment could only be confined to pre-GST era as far as VAT laws are concerned. Anupji.
Yes, yes. Sir, one question I would like to ask to Pandey, sir. Sir, in this particular judgment, the resolution plan approved by the COC is set aside, and the resolution professional is actually directed to consider for a fresh resolution plan. So do you see any possibility of these authorities, statutory authorities, even coming for sitting in COC?
No, not as a operational creditor, of course, that is not possible. Only thing that will add to confusion in distribution, not in COC. COC, it is very clear that only financial creditor will sit. They are only secured operational creditors. So as such, they have no right to sit in COC. Only in the matter of distribution, whatever they decide, these operational creditor will go to the court and contest that COC has decided and not given us our reasonable dues. That is the challenge I see here, because again, COC will look at its interest and interest of other operational creditors. And as Mr. Magija and Mr. Madan very lucidly explained, that ultimately the fundamental of law is that the government dues takes a backseat. They are at number 5. So why push them in between? So that is only adding to confusion, nothing else.
Magija sir, my next question is to you. Simple, short question. Shall the government dues are in the nature of, they are the operational creditors, these government departments. But if they are paid on pro rata basis vis-a-vis the financial creditors, shall they come in that category, or shall they not be in a position to jump to from operational creditor to financial creditors category?
See, the issue is, number one, let's understand government dues, whether sales tax dues or any other dues, they will remain as operational creditors. They cannot be in the category of the financial creditor. Now, being secured creditor, so particularly they relied upon Section 48 of GVAT Act, which is also quite similar to Section 82 of GST. So the confusion will always remain that, look, whether the sales tax department or GST department or any other department will remain a secured creditor or not. Now, if they say that, look, if they are secured creditors, that is what I said, the problem, where the problem is coming. They are considered as secured creditor, though operational. Now, they are protected under 32B. We can't ignore the impact of 32B. 32B takes into account notionally 53(1)B. So they say secured creditor, so therefore you must pay. So that is why I said, look, everyone is saying review and stay. That's all right. I am simply saying, because at the end of the day, most of the time, whenever a judgment is passed in income tax matters, the finance bill comes and they overrule the judgment, isn't it? Override that judgment. So we have to be very fast in amending the law, whether reviewed or not reviewed. Tomorrow, you see whether it is per incurium or not, because you see some may argue against that also. Now, per incurium is like if both of them are the same and they have not taken into account. Fine, Ghanshyam Mishra is not mentioned here, but how it is applicable? Ghanshyam Mishra only says a clean slate, that once the plan is approved, it gives a clean slate. That is all right. Nobody is denying that. Nobody is denying the commercial wisdom. But the fact of the matter is, whether they are secured creditor or not, that was not dealt by Ghanshyam Mishra. So therefore, you see, these are two are different, in different domain altogether. So my suggestion is very forcefully, you have to amend the law. And only then the bank's confidence will come back.
Madan sir, your final comments. Sir. Yes, sir, Madan sir, your final comments.
I have already made this request to IBBI Executive Director a couple of days ago in a webinar of ASSOCHAM. That was, we need to have this amendment. Until the time the Parliament meets, this amendment should come by way of an ordinance. Without delay, this amendment should be there.
Madan Sahab, I think we are all aware that IBC has got a unique achievement. For last 5 amendments, they have all come through ordinance first. The bill has been passed, and every year there has been an amendment. So I don't think I'll be surprised to see any ordinance in this also.
My final word on this was 2 final words. Number one, my dear friend Nipun just said that now there is a liquidation application is pending before the adjudicating authority. Now this order says the RP may consider a fresh resolution plan. First of all, it's not the RP who considers the resolution plan, it's the COC which considers the resolution plan. And a plan which was not having this statutory dues, now the court wants a plan with statutory dues should be there, and the COC will consider that. How will the COC going to consider it? And they are saying the RA this RA is also entitled to submit a fresh resolution plan. Was the court not aware that the liquidation application is already pending before the adjudicating authority? Now, because of this judgment, whether COC will be mandated to consider or to invite a resolution plan and to consider that, all those I think questions are yet to be answered. And my final word on para 57, sorry, not 57, para 53, to Makija Saab ne bahut achhe beautifully explained kiya hai. Para 53 of this judgment actually is against the preamble of the code.
That's right, sir.
But yes, preamble of the code does not deal with liquidation of the corporate debtor at all. It simply talks about restructuring, revival, resolution. But para 53 says if government dues are not considered, the company would necessarily have to be liquidated. That's not in the right spirit, that you are leading to liquidation rather than having any resolution or restructuring.
So thank you so much, Makija. Just before I move to the next round of taking questions from the audience and request answer from our esteemed panelists, I'm having our 3 distinguished guests, Mr. R.K. Poddar Saab, Mathe Taragan, and Ravi Kumar Ganti Saab. I request Vinod Saab to introduce them, and then I shall take 1 question each from them. Thereafter, I shall open the forum for all the participants.
Yeah, Poddar sir, thank you, Anupji. Poddar sir is a great personality from the corporate Mumbai, and Poddar sir is a mentor and consultant. I mean, our what you can say, the committee of consultation head, and that's what about Poddar sir, having a huge experience in the corporate as well as in the financial restructuring. He is also an IP. Next, Mr. Matthew Taragan sir is an ex-GM from SBI, having a lot of experience in the area of risk management. Mr. Ravi Kumar Gandhiji is also from a corporate sector. So that's what the brief background of experience. So we kept the special guest in such a form that yes, it will be much more useful for getting hear from them. Thank you.
So I would like to take the first question from Ravi Kumar Ganti sir. Sir, would you like to ask any question to our esteemed panelists, sir, on the issue?
You want me to ask the question or answer the question? Okay.
Sir, whatever way you like, sir. Your comments.
Yes, basically, I think they have covered almost everything beautifully. There's hardly anything left to ask of them. Except I just wanted to make a few observations, taking off from where the panelists have already spoken. 2 words I want to pick up from the judgment. One is the word used by the RP in his communication to the VAT authority. Your dues are waived off. RP hota kaun hai waive off karne wala? You know, sometimes these things matter. You know, the word you use, it's like, I think the advocates here will agree with me. If you take a plastic knife and fight with it and somebody dies, as opposed to a regular, rampuri, you have, you are looked at differently. So the words used are so important that it can trigger. It should not, but we are all human. Psychology matters. Okay. The second word is from the judgment itself, where they say ignored altogether. Ignored. Okay. The word ignored is important. And I would like to take it back with what the regulations say, that there shall be a statement which will specifically say how the dues of each party or the claims have been addressed in the resolution plan. Okay. So use of words like waive off means that you are assuming an authority which you do not have. But if you say the same thing, if you say, yes, I am recognizing this claim, I place it here in terms of the law as it stands, section 53 read with section 30, and I am assigning the value of so much in payment. You have addressed it. You have not used authority which you do not have. So sometimes these small things matter. Another comment which I would like to make, not comment, just an observation, that this judgment is not incorrect wholly, it's partly correct, but it is incomplete. And one of the other judgments which we have to read with this, because that also came very recently, is the ABG Shipyard judgment in the CBIC case, where I think a lot of things have been clarified about what an authority can do, what is the meaning of an attachment or an encumbrance, and still they have to file a claim. I think from that, if we look at it, all that requires, as Makhija, I think very eloquently put it, that in 53(1)(e) just adds the words that whether secured or otherwise, in that problem is solved. Just one amendment. 53(1)(e) should include the words government dues whether secured or otherwise. Everything is over. Straight away from B, it will come down to E. This judgment will then be only of academic value.
So, thank you so much, sir. Now I request our second distinguished guest, Mr. Mate Tarakan Saab. Sir, your views, please. Your question or views, whatever you like, sir.
I know, but I just want to dwell on what is already stated. I just wanted to ask a futuristic question. When I joined the bank, actually, there is only the normal civil procedure code for recovery of banks dues. That is the only thing is available. Then the government brought in 1993 the great REDB and saying that it's something great and the banks will have some miracle, 6 months, all the things will come. But that failed miserably, and it is failed by the Honorable Court of Laws. I mean the DRT specifically, which turned out to be a white elephant. And again, the government brought a SURFACE Act in 2000. Okay, it also has its round of success actually. And again, it is dragging because of the many provisions, particularly section 17, which comes to the DRT. And I myself personally have a lot of experience. It goes on dragging like anything. And finally, now we have the IBC, and within a very short span of time, see, hardly 6th year, we have this, what is that, a judgment which pulls back the whole impact of it. So is it that the courts are failing the ecosystem for the bankers for recovery of dues, or the bankers or financial institutions? And is it necessary that the government has to bring in one more new act? I'm sorry, it is not a criticism for the lawyers, the honorable lawyers present here, or the courts. Thank you.
Pandey sir, would you like to give a quick response to what your sir has said?
I think you'll ask Mr. Madan.
Madan sir?
Anji.
Sir, quick response. Pandey sir is requesting from your side.
Sorry, I missed the question. Sorry.
May I just briefly say something on what he has said? I think all things considered, assume we IBC has not lived up to this very exalted, levels that we thought of expectations. But can anybody say anything else has been better till now, even today? It's bad. It's like somebody defined democracy. It's the worst form of government, but we don't know any better as of now. So IBC is still the best. It has its problems, and I think we will solve it over a period of time. One just needs to look at the criminal law side of this country and the harrowing conditions that litigants face there. People who are staying in prison because they can't afford bail, more than the the maximum sentence that they can get. Compared to that, we are far better. I think we are crying too much. We should not.
So thank you so much, sir. Now I request our R.K. Poddar Saab to come live and say a few words, question, comment, whatever, sir, as you may.
Okay. Thank you, Anubji. I think our panelists have really explained the whole thing very well. And IBC, I always used to admire IBC. IBC is a very good law which they have brought in. Unfortunately, the teething troubles, as Dr. Sahu used to say, are there. And those teething troubles are going longer than 6 years. We thought that it should be over in a year or two. They are over. So it is basically the understanding of the attitude of the people who are involved in this, and the legal side of the matter can be dealt by the lawyers, and they have really dealt it very well. And I think the rainbow has really put the whole IBC into a fix, and it should be reviewed or stayed, or the modification in the law should come in very fast. Otherwise, as is pointed out by Mr. Madan, that all the cases wherever even the resolution have been passed, have been implemented partly or fully, they would come and a lot of litigation would go on. But definitely it is a good scenario for the lawyers to earn more money, definitely. Unless
Thank you so much. Thank you so much, Madan sir.
Poddar Saab,
I think you. Yes, sir. Please, sir. Please, Madan sir.
पोद्दार साहब, लॉयर्स के पास भी काम तब आएगा जब क्लाइंट्स बचेंगे तो.
सर, क्लाइंट्स हिंदुस्तान के चार्टर्ड अकाउंटेंट्स को फीस दें या ना दें, लेकिन लॉयर्स को फीस जरूर देगी लड़ाई लड़ने के लिए कोर्ट के अंदर.
So, thank you so much, sir. I request Mr. Sumit Kansal ji to ask his question. I saw his hand raised. Sir, Sumit Kansal.
Thank you, panelists, for the wonderful inputs. My question is to Makija Saab. He's very wonderfully explained the judgment in detail. Sir, it is pertaining to specifically para 56, which says section 48 of the GVAT is not contrary or inconsistent with section 53. For a moment, we assume that tax interest penalty is the first charge, and 53 says that the proceeds from the sale of liquidation. So it does not talk about the priority, but the proceeds from liquidation. Now, it further says, the para 56 of the judgment, under 53(1)(b)(2), debts owed to a secured creditor, including the state under the GVAT, to rank equally with the other specified debts, including the workman dues. If we happen to read 53(1)(b)(2), the debts owed to a secured creditor in the event, even if for a moment we consider that this statutory due is in the sense of a secured kind of a debt of the government. It's an OC and it's a secured debt. It says that such secured creditor has relinquished security in the manner set out in 52. Now my question is that as per the facts of the judgment, there is nothing to state that this secured creditor has relinquished the security and it should be in consonance with the workman dues. And I think the Honorable Supreme Court has erred in law in para 56 to this extent. What would be your views? Because no relinquishment has happened of the security interest.
Okay, Sumit, I think you have asked a very pertinent question, but let us understand this judgment in a different manner. When section 32B gives a reference to 53, it is giving in a notional manner. There, we are not talking about relinquishment or non-relinquishment. Relinquishment or non-relinquishment, Sumit, it happens only in liquidation. So when it is only a presumptive, it is a deemed kind of a fiction, which has been created under 32B. Assume that you see the relinquishment has been done. Now, if you distribute in accordance with 53, what they are supposed to get. So probably we are just presuming that relinquishment is already done in CIRP. When it comes to liquidation, yes, you are right. Section 52 takes precedence where you have to talk about the relinquishment. Now that brings another question. Supposing their charge is not registered and assuming under section 77(3), which I read, somebody says the charge was not required to be registered. Now the second question is whether relinquishment is required now by the state sales tax department or not. So therefore, you see, it leaves, you see, a lot of questions rather than answering the whole thing. In fact, I must also point out, in the other day, Mr. Madan also pointed out, there is a judgment of Honorable Supreme Court on 8th April 2022. Now, which talks about, which is Money Lakshmi Metal and Alloys versus State of Gujarat. अब ये निपुण नहीं बताएगा कि ये सारे गुजरात के केस क्यों सुप्रीम कोर्ट में जाके और स्टेट गवर्नमेंट के आते हैं. And you see, look at the sentence which is written there. You see, in the last, you see what they have written. They say, in view of the aforesaid, the writ application succeeds and is hereby allowed. It is hereby declared that state cannot claim any first charge over the subject land by virtue of section 48 of the GVAT Act. Now, there the judgment is little different. It is completely reverse. Because there they were comparing whether the bank's dues override the GVAT, I mean, the sales tax dues or not. They said, sorry, because of SARFAESI, which you also pointed out, they said SARFAESI will override the GVAT, and even under 48, they can't claim a first charge. So if I read that judgment along with this judgment, now insofar as clarity is coming that, look, they don't have a first charge, so they cannot claim it. They may be secured, but they cannot claim a first charge. So therefore, the distribution in accordance 53 will not include them if I read both the judgments together. So I think if we read that judgment also, probably things will be very, very clear. So
very well said. So from your discussion, I found that there is kind of a mixed views. 52 to 54 paras you say are draconian, and you do support certain paras and crux of the judgment also. What is your final one view upon the judgment? Like, do you support it or are you against it? Or to what extent?
Well, Sumit, as lawyers, I think very senior lawyers, senior professionals, and senior bankers are there. Well, I don't consider any judgment to be impediment. The point is, it's a nothing but evolution. We are evolving the law. Sometimes you will be depressed with that judgment. Oh, it is definitely like Madan Sahab said, black clouds or dark clouds. So IBC will be shut down. Well, temporarily, yes. But otherwise, I don't feel so, because the government is also very proactive. We have seen the flexibility in amendments which are happening. So we will see that after the tunnel, the lights, we will definitely see bright lights.
Very well. Many thanks. Thank you.
So may I request the audience to ask next question?
Sir, may I add something?
Yeah, please, sir.
So Makhija sir, why I was referring to this Gujarat VAT issue with respect to IBC, I'll just share the judgment. Alpesh Jain's judgment of Gujarat High Court, which is with respect to IBC, GVAT, municipal corporation dues. They have relied on Ghanshyam Mishra. Now, basically in Ghanshyam Mishra, it talks about three things which I suppose with respect to this judgment, we can correlate. One is with respect to the timeline for claim. Because Ghanshyam Mishra says that if claim is coming, considered in the resolution plan, done and dusted, after that, nothing to be considered. Second is, in that judgment, it's a batch petition judgment, where specifically commercial tax and sales tax department were also there. So that particular thing will apply. And third, if you see the concluding para, where the resolution plan 3031 section, which here they say that it should have been rejected by the adjudicating authority. In that judgment, it upheld the resolution plan. So my view is, if you compare both of them, and that also again GVAT judgment which you have said, sir, and also the High Court judgment, if we look at the totality of things, probably this could be one of the points to be argued, that it is ignoring the already settled position of law. Now let me share something for all the participants. I am having the resolution plan of Rainbow Papers. So if permitted, I can share it on screen.
Yes, please, sir. Please.
So this is the resolution plan of Rainbow Papers. So it's in public domain. So I am not infringing any confidentiality, because this is basically a merger of Rainbow Papers with Kushal. So you can see this, and I am just taking directly to the claim. Now you see, this is the proposal for statutory dues, wherein the sales tax amount, you can see it. This is the amount here. Now, if we see the breakup, now let me take you to the breakup. Here it is sale tax, VAT for so many years. It's totaling somewhere around, I suppose, 36 crores. So probably the observation in the order which says that it is not being considered is, I think, somewhat correct or misplaced, because they have considered it, they are paying for it, and these are the claims which have been given by the RP as per its IM, because this is basically a scheme of merger. This resolution plan was basically a scheme of merger. So it's a public domain document. And I think I will also take you to the payment schedule. I think I missed out the page, but the payment is also given with respect to each category, how much they are paying.
Okay, what is the payment, proposed to be paid to sales tax?
Yes, sir.
To the VAT department?
Just 1 minute, sir. This is the proposal for payment.
So they are paying 82 lakhs to the sales tax, but VAT department is missing here.
Sir, here the VAT department, sales tax department was renamed as VAT. So they have put one broader category only. But the
earlier page which you showed, you see sales tax.
That is claims.
They were two. So claim, sales tax and VAT, they were two categories earlier. So I don't know.
No,
you may be right here.
Sir, normally here what happens in Gujarat is they put it as sales tax only because here the name has not been changed of sales tax department to VAT department. That was a very interim period, and then GST came. So normally they refer it to as sales tax. So this is broadly the category in which they are making the payment.
Even the judgment says state tax officer, not the sales tax officer or the VAT tax officer.
Interestingly, one more thing which I had discussed off the record with some of the state tax officials, what they said was that, see, as per Gujarat VAT, it got subsumed. Previously sales tax, then Gujarat VAT, then GST. Now under GST, the jurisdiction is like this, that for the past dues, they have authorized state and central tax authorities to adjudicate and to enforce the outstanding dues. Now, in this particular case, for the rainbow papers, this was specifically given jurisdiction to state tax officer. So ultimately today, because of the repeal and the saving clause, this particular amount, which was due to the sales tax department, which is state tax department, is now claimed by GST state department officials. So that's how the structure flows here.
Okay, thank you, sir. Now I request Mr. Adil Parker Saab to come and ask his question.
Good evening, everyone. Am I audible?
Yes.
Yeah. Actually, I have a confusion and a query. The confusion here is that in this case, after the CIRP, it was stated that the sales tax officer had initiated the attachment proceeding. And so now my question is, until and unless any amendment or review happens and we are facing a claim from a GST department. So my question is, let's say, even unless by operation of law, if they are becoming a secure creditor, so until and unless the GST authority pass an order and they initiate the execution of order by attaching a immovable property, or let's say because they also have a lien on bank account of the corporate debtor also. So in that case, if they have not initiated any order or before, CIRP, if let's say the CIRP order has passed and there is no order or any execution happened by the GST authorities, so whether they will be a secured creditors? I mean, what's the actual operation of law here?
See, Adil, you are kind of, mixing two issues. Let us understand, one is whether they are secured creditor or not. The Supreme Court says they are secured creditor by operation of law. So we'll have to, so if any government department or statutory authority files a claim to the RPs, what the RPs will have to do is they will have to read that particular act now.
Yes.
Right? So whether 4 claims come, so you will have to read those 4 acts. So first you decide whether they are secured or not. That's one part. 2, see, recovery and confiscation and attachment is something different. That cannot override the IBC. Please understand, there are 2 different aspects. Whether their claims can be 100% haircut or not, that is what the judgment says they cannot be because they are secured operational creditors. But confiscation, attachment, most of the departments, custom departments, income tax, they do. But then we approach NCLT and we got a detachment. We get detachment. And most of the cases, I think 99% we are getting detachments. Because their section 238 will come into play. Because then it becomes inconsistent to section IBC. So therefore, these 2 aspects are completely different, according to me.
Okay. Thank you, sir.
Okay. So the next question, anybody?
I think Mr. Ganti wanted to say something. He was. wanting to say at that time. Yes, sir. We would like to hear from you.
Sorry. Just wanted to, in fact, even ask you that the definition of secured creditor in IBC is the general definition, which is there in Companies Act or other insolvency laws elsewhere. But there is a very, very specific and special definition in SARFAESI, which is it is an exclusive list. It's not an inclusive definition. Only those which are mentioned there are secured creditors, and it does not recognize government use of any kind.
Correct.
Right. So if when it goes to SARFAESI, the same party will have a different standing because 36E is very clear and there is no confusion there. So to merge both, because both these laws need to be in harmony. Even in IBC under liquidation, somebody wants to go to SARFAESI, it can't be a different definition altogether. It should only be a different manner. So what you are saying is that some amendment needs to come to clarify. I think I just wanted to mention that there is this inconsistency between the two, which needs to be harmonized between SARFAESI and IBC also.
I would only say, look, SARFAESI is a special act. Now it wanted only give a draconian powers. I would say use that word draconian powers to the bankers and the financial institutions and the ARCs. Look, if I'm a financial creditor, not a bank, then I can't go under SARFAESI. It is only the banks, financial institutions, or the ARCs which can invoke the provisions of SARFAESI. So SARFAESI is a very special act. Therefore, their security interest definition is different. But we can't bring that judgment, that definition into IBC because IBC has a specific definition of security interest. But yes,
I was not talking of bringing the definition. The intent was already there in 53(1)(e). Just needs to be clarified.
Yes. That is what we have been discussing. Great.
Sir, why you say that SARFAESI is draconian? Is it because the bankers who give the loans are themselves trying to recover and not going to court?
No, I'll say draconian for a simple reason. First, you see, in 1992, when the economic reforms came in, we all know that reforms came for the first time. Now, at that time, NPAs were quite huge, like we have NPAs today. So the government said that, look, let us bring in, RDDB Act. So in 1993, recovery of debts due to banks and financial institutions, they said, let the banks not go to the civil court, but let them go to a special court, which is DRT, so that it will be a summary procedure. But still, but since DRTs were not very, they were failures to that extent. The banks were not recovering money, so they brought in a draconian power. Why I'm calling draconian is because now, without the judicial interference, SARFAESI says banks can take over the property and also the management of the company without the judicial interference.
Now, what is wrong with that?
No, I'm not saying wrong or right. There is an act. Obviously, we are bound by it. But I'm saying they gave huge powers. Maybe draconian word was not a good word, but I'm saying they gave a huge powers to the bankers to use that. But ultimately, we also know that even SARFAESI was marred into a lot of litigation. So banks are not even using that powers also to sell and recover the money. So they thought IBC will be much better. But with these judgments now, well, I think Sanjeev Pandey ji is thinking now.
Sir, if I say that courts are failing the banks in recovery, is it
not exactly? I won't say that, sir. That is a draconian statement now.
I would like to take 3 more questions from the audience before I request Paramjit Saab to give a summary of whatever has happened. 3 more questions from the audience. Anybody?
May I ask, sir?
Please, sir.
May I?
Yes, sir.
Yes, sir. Section 11(2) of the PF Act also contains similar provision, like Section 48 of the GST Act, that unpaid dues of PF will be first charged on the assets of the company. PF dues have already been a matter of contention before the Supreme Court also, and various cases has been decided. Whether this will have an impact on the PF dues also, in what manner, I would like to get clarity.
May I answer this? I'll tell you, I think Mr. Anganathan, you have again, touched a very, very important chord. You see, before we deal with IBC, I think all of us must read one Supreme Court judgment, SK Pharmaceutical, 2011 judgment on PF. Now, in that judgment, Supreme Court says that PF dues are over and above even the government, even and above the bank dues. So relying upon that first charge, and they only say not only the amount, but also the penalty and whatever charges are there, they will have to be paid first if a company is in winding up. According to me, the same principle still operates unless and until we clarify in our own. And we have seen, as far as the PF is concerned, we have seen number of judgments which say they are not part of the liquidation estate, so you have to pay first. So I think we have already seen that some kind of these things. But SK Pharmaceutical 2011 Supreme Court judgment in Winding Up of Companies Act is a very, very hugely important judgment, which all of us must read that judgment.
So the next question from the audience, please. Vinod Saab, shall we?
Anupji, actually what happened, the panelists compiled everything and discussed all the matter. Now I was checking with some people. They are already prepared question. I was asking, why don't you raise the hand? Yeah, everything is completed. Then what?
Sir, I did lot of homeworks. I written nearly 7-8 pages, but I think most of the same is answered. I am not having any questions from the esteemed panelists. So,
exactly.
so
Mr.
fantastic.
Yeah, Mr. Parsoya come with the well preparation, but I just asking him that everything is covered.
Yes,
I
sir.
think
Yes, sir.
it is went through unless and otherwise somebody is having still a problem.
I think you also brought, you see, rainbow panelists. So number of panelists were equal to the rainbow colors today.
Great, sir. Great. So I would like to request our board member, Mr. Paramjit Sethi, to say a few words before we conclude with vote of thanks given by our other board member. Paramjit Sethi, sir?
Yes, sir.
Please.
I am audible?
Yes.
Okay,
Loud and clear.
Okay. Thank you, Anupji. So we are pleased to have such august gathering of our participants in this knowledge sharing webinar of PIPPL. And we are also sorry that some members may not join due to some maximum number of issues was there. So we will cure it up in the due course, and we will manage to provide the videos in our YouTube channel. And we are also fortunate enough today to have such an renowned and famous dignitaries on the panel of our discussion. The presentation was so excellent that attendance was always full to the maximum level, and think we will be this panel of participants was so beautifully explained everything that there was least questions, whether it was Pandey ji, Makhija ji, and Madan Saab, Singhvi ji, Ravi Prakash ji, Podar Saab or Tharakan Saab. Everyone have given their expert advice, and I think all the participants have got enlightened from their knowledge sharing views. And going forward, we are going to have such a webinars on IBC, and we will be sharing the link and details in due course. So request all the participants to bless us by joining our webinars. We are happy that so big number of participants have registered. The registration was approximately 300, but we could not accommodate them. We once again pardon. And if there is any suggestion from the participants, they can give us any suggestion for improvement at our email address info@pippl.in. We have also have YouTube channel. Please subscribe to our YouTube channel. And today's webinar is also we have published on the YouTube channel, and the link to that YouTube audio video is also given in the chat box. Please join from them. I after my speech, I will once again give in the chat. So please, thank you.
Yeah. While there is a technical hitch happen, we are tracked most of the people to the live channel. Live YouTube, and there 25 people was maximum attended, and still some 15 people are still watching the things. So good things happened, but we understand that we went for 500 number, but it's a webinar serial, correct?
Yeah.
Fantastic. Now I request our board member, Mr. Rajendra Puranik ji, to give the vote of thanks.
Yeah, thank you. Am I audible?
Yes, loud and clear, sir. Please.
Yeah. So I have this onerous task of saying thank you to all of you. Actually, we can say almost 5:40. So it is a 2.5 hours journey of knowledge sharing with experts like Makija sir, Pandey sir, Madan sir, Nipun Singhvi sir, and then our moderator Hon'ble Awasthi sir. It was a nice discussion. I think basically we discussed two amendments. One is 13 September 2022 amendment about professional fees to IRP and RB. At least now we'll have a baseline figure of 1 lakh rupees per month. Otherwise, many IPs are putting less than 1 lakh. So at least now we'll have some this thing. And then another rainbow discussion. It was a very fantastic discussion. What Awasthi sir said about 52, 53, 54 was very knowledge sharing, because she specifically given detailed explanation of 52 or 53, 54. So I think though Madan sir said is a black cloud judgment and maybe, but sir now already IBC is in the 6th year, so I don't know if it will be scrapped. We have to come out with some amendments, and definitely we will come out with the amendment, and maybe some review will be taken about this rainbow case, and we will move forward, because a lot of IPs are passing the examination, so they will be now where to go for them now. So I think something will happen in this rainbow case. So with these two discussions, we got highly enlightened. So we are happy, and we can say at least I am happy. At least I learned a lot of things with Awasthi sir's presentations and deliberation by the Singhvi sir, then Madan sir, and our Poddar sir also gave some inputs about his knowledge on the IP. Then Tharakkan sir also gave his special inputs. Then Ravi Prakash Ganke also participated well, and other members also participated. What Sethi sir also said, ki almost 300 people joined, but because of some technical glitch, some only 100 could join here. Some are joining on YouTube also. So maybe next time we'll take care. So with these words, I will say thank you to Anup sir for moderating this session excellently. Anup sir asked a lot of questions. So we got also understood so many things about this rainbow case. Then I will thank our PIPPL board member, Vinod sir, then Prasad sir, Ramila madam, Sethi sir, Kaushik sir, Vimal Kumar sir, for taking extraordinary help for making this event a grand success, because they are working on this webinar for almost 7 days, day and night. So I will extend hearty congratulations to them, because they have made this event a very grand success. Then I would like to close this event with two reminders to you that we are having one more session on 24th of September, Saturday, about IBC background and initiation of CIRP. So that session is there on 24th September. So please join that company, join that webinar. And second point is that I know it is not the correct way, but if any member would like to join our company as a shareholder or a member or advisor, we would request you, because we are 127 people all over India. So if anybody wants to join our company as a member or well-wisher, we welcome that. So with these words, I would say thank you to all of the members who participated, and almost 77 members were there till 5:30. So it was a nice interaction with all the members. With this, I will say thank you. Thank you.
Madan sir, I think you want to say something in the end?
Nothing.
So, with your permission, sir, Makija sir, shall we close it?
Yes, sir. Thank you. I think we must say that we must thank all the organizers. It was a wonderfully organized program. I think the panel was excellent. I mean, it gives us an opportunity to interact with all our friends, including Mr. Ganti, Mr. Nipun, Sanjeev ji, Madan Saab, Poddar Saab. I think it's very good to see and interact with all these people. The brains coming together, I think that's the wonderful thing. So you guys are doing a good job. Please continue to do same kind of seminars. Thank you so much.
Final words, Mr. Nipun Sanghvi ji, something? Anything? Few words?
I will keep you updated once the petition is filed, review petition is filed. Because I think I will be coming to know first, because being from Ahmedabad. So we will be coming to know, because every day that is rainbow paper is only going on in NCLT. We all are taking adjournment. Sir, rainbow paper, please adjourn. That is how here we are working.
Final word from Pandey, sir.
Thank you. Thank you. I think the excellent webinar. And thanks for Mr. Makija, Mr. Madan, Mr. Napun. Excellent discussion happened here. And I go away very much enlightened. So thank you so much.
Vinod sir, would you like to say something?
Yeah, I don't have anything to say. I never expected things will happen like this. Really appreciable on the efficiency and the accuracy of the panelists. There is no wonder they are trained like that. Okay. And on 22nd to 6 o'clock, we are again scheduled a meeting on all the amendments, right? And I'm having discussion with Nipulji for the Gansham case and all those things. It is separately scheduling because there is so much demand is coming from the members and the external party. So our series is going. Good thing happening, and not having more than to say. Thank you, Anujji.
Thank you so much. So now we may close it. Thank you.
Thank you.
Yeah.
Thank you.
Thank you, sir. Thank you.